potential costs or not? I think it's
certainly have no objection to you sounding initiate a ward response if the behaviour is deemed reasonable and led to unnecessary wasted expense. Excuse me. However, submitting that evidence doesn't
for a long time that the saltwater created drain line being environment regulation in line.
Does built-in EA standards and that equate leak pollution prevention? Are they
So, well, they overlap. They all entering. I would overlap. Environment agency prohibit. Also say certain water. Also they recognize.
Bachelor?
Thank you, sir. Your question was how do you determine what is a suitable foul drainage means? This is really the fundamental question. What's Condition 13 trying to do? In Council's submission, Condition 13, a classic, I would call Barrett condition. And you've got attached to our statement of case both the Barrett condition in that case out by the court, paragraph 19, and it's materially identical to the 13 case. They both require submission of a scheme prior to occupation. Role that the Court of Appeal and Supreme Courts billing is to ensure that there was adequate off-site capacity to deal with as well as regulate going on the application. And you see that note most clearly paragraphs 47 of the appeal and paragraph 47 of the essentially both dealing with a question about the absolute right of an undertaker to develop to connect to the sewerage network and recognise the real problem, the inability of the undertaker to refuse connection until they had upgraded their infrastructure. And both courts recognised the proper role of the planning process in effectively controlling the sequencing of events. And condition, the condition in that case, because it was condition 10 on the permission, quoted at paragraph 19, worded the same as condition 13 here. They said it was the only way of deferring connection through the planning process until sewerage capacity off-site had been proven to be satisfactory. So in answer to your question, condition 13 is looking both on-site and off-site. The specific question it's looking at off-site is whether there's adequate infrastructure capacity. And you've correctly focused on decision letter paragraph 35. It's relevant to note what the inspector had before him when he imposed that condition. So you've got in the bundle, it's page 13 of the council's statement of case, the Southern Water, 14th of February 2022, representation on the outline application. And you'll have seen that they responded to that, saying they'd done an initial desktop study. The additional flows may increase the risk of foul flooding, and so they were positively asking for a Grampian condition in the Barratt form. There were also objections. I'm afraid you've been given all the objections from third parties, but the ones that are relevant are at page 77 of the statement of case, paragraph 18 of Horeham Parish Council's 15th of February 2022 letter of objection, which said there was inadequate sewerage capacity, and then their 22nd of June 2022 objection, and that's at page 143 of the statement of case. So essentially the inspector had both the statutory undertaker and the parish council saying there was inadequate capacity and there should be a Grampian. That's the context in which decision letter 35 was written, and condition 13 in materially the same form as the Barratt condition itself was imposed. So squarely condition 13 is asking, is there adequate sewerage capacity off-site?
Right, okay. Thank you, Mr. Moores. Did the appellant want to say anything in response before I move on to my next question?
I'll deal with the Barratt points, and then perhaps I can ask the remainder of the team to explain the change in position from Southern Water since 2022. So the starting point really is obviously the council are asking you to look at off-site issues on the premise that the condition is similar to that in the Barratt case. And I think it's essential that you have some context really, sir, for the Barratt case. Barratt was dealing with, we say, sir, a fundamentally different case. It was not a case that was really talking about the ambit of planning conditions, but rather was concerned with the ambit of the power in Section 106 of the Water Industry Act of 1991. And so that power really is concerned with developers who are trying to connect into a system and the extent to which a statutory undertaker can refuse a connection. And again, to put a bit of flesh on the bones, as it were, by way of background, Barratt's in that case were in the process of building a substantial development of some 98 houses and a primary school on a site, a greenfield site, in a place called Llanfoist. They constructed a private sewer to receive the sewerage from this development. They claimed a statutory right to connect their private sewer to the public sewer at a point of their choosing, which was close to their development. This point of connection was not deemed to be satisfactory to Welsh Water, who were the statutory undertaker in that case, because it would overload the system upstream of that particular manhole. Welsh Water then claimed a statutory right to refuse connection at that point, offering instead a connection at a different manhole, an option which would in effect saddle Barratt's in that case with the cost of the link from their development to the relevant manhole. And we say, so it's essential that you consider the Barratt decision in that case, in that context. Accordingly, the essential point, which required resolution in that case, which found its way all the way to the Supreme Court, was fundamentally about this issue of the rights of Barratt to connect into the public sewer. And really, it was a question about kind of who should pay for that connection. There was also a secondary issue in that case about whether or not the undertaker had notified the developer in time that it was refusing permission. And again, that's not an issue that needs to trouble you. None of those propositions are an issue in this case, sir. Most notably, firstly, there is a statutory undertaker who supports the connection. That is fundamentally different to the Barratt case, where Welsh Water were actively objecting and indeed took the case all the way to the Supreme Court. Secondly, there is no issue between the parties about where the connection will take place. That's all agreed. Thirdly, there is no issue about who will pay for it. There is a diversion proposed, which we will explain in just a second, but that issue has all been resolved. And fourthly, there is no issue about the 21-day time limit for a statutory undertaker to raise any issues that it has. So it's hard, with respect, sir, to see why the council places so much emphasis on the Barrett case. I accept what my learned friend says about the Court of Appeal judgment, paragraphs 47 and 48, which explain that a local planning authority can refuse permission until drainage requirements are satisfied. My submission, sir, is that's not part of the main ratio of the decision, i.e. it's not part of the main decision, it's part of the obiter comments of the court. But however, that point aside, the principle of off-site works requiring a condition, in turn necessitating an agreement to ensure that they are carried out at the expense of the developer, of course might be necessary in some cases. Barrett's was a classic example of where that might be necessary. But in this case, the imposition of such a condition would need to have met all the relevant tests, including in the relevant tests in the framework. And we say, sir, that the position is fundamentally different in this case, not least because Southern Water agree that there isn't an issue with connection in this case. And if I may, I'll just turn to my right so that further explanation can be given as to the difference in position between 2022 and now, and how matters have fundamentally changed and have moved on.
Okay, thank you. Is this also covered by the Southern Water letter?
I think it's covered in a great number of their consultation responses, sir.
Diversion, which was
Okay,
one
fine.
of the...
Sorry, yes, the diversion point is the one which
Yeah.
we're going to address.
So back in 2022, there was a sewer that Southern Water building control team recognized that it needed to be diverted to enable this development in layout, and Wilden was in agreement that until this diversion is secured, there is a risk that development would have to change to accommodate existing sewer that was crossing the site. And Southern Water, in consultation with Monson Engineering, obtained S185, which is the sewer diversion agreement, which will be completely funded by Chaley Homes, but it will be executed by Southern Water. And in terms of the other approach, there it was back in 2022. From what we can see, just very quick, there was a desktop study, whereas at later date, Southern Water Bill stipulates in the letters in consultation that they undertook a hydraulic modeling of the sewage system in that location, which determined available headroom for this development or any upcoming developments in this area.
Okay, thank you very much for that. From what I can gather, it seems that the council's main concern is about the effects on the system when it becomes overwhelmed by rainwater ingress during certain rainfall events, and not due to its typical operation under standard conditions, whatever standard means. What certainty are there of these weather events that cause the discharges and the overwhelming in the future? And are you able to give me some idea about where these ingresses occur and the likelihood of the number of events per year? Basically, I'm trying to understand certainty and location of such events.
So I think the starting point, you've got attached to the council's statement of case the Southern Water plan, the drainage and wastewater management plan for the Vines Cross wastewater system. That's, I think, page 155 of the statement of case, if you've got it as a PDF. Page 155. So this is Southern Water's own document, and that details past performance and identifies hydraulic capacity as being the problem with sewer flooding risk. It also then deals with ecological status at planning objective 9, and the table that's adjacent to that says that the water bodies connected, so that's the Walder and Gill, among others, are not achieving good ecological status. The Environment Agency says the reasons for that are the operation of the water company. It assesses the risk as being the worst, bad, very significant, recognises they might not be complying with their Environment Agency permits, and the activity that's causing that is sewage discharges. You then see the generic assessment at the end, page 163, where the prescription is to reduce infiltration into the network. They don't go so far as to identify where that is. That would require on-site investigations by Southern Water to determine precisely where the water is ingressing. But their own document, their own plan, recognises that there is a problem with hydraulic capacity. It is caused, among other things, by infiltration. It will persist, and they're proposing firstly infrastructure upgrades that will take place after 2030, and secondly measures to combat infiltration, which haven't been particularised. But there's no suggestion in their own plan that this is not going to continue occurring without intervention. They're recognising in Planning Objective 9 that the ecological status of those water bodies is bad. The Environment Agency attributes it to their activity, and therefore they're proposing in the table at the end the generic options assessment for Vine Cross to take action to deal with it. And you've got their correspondence in relation to this appeal.
So, Mr. Moores, you referred me to page 163 and 155. I wonder if you've got a single PDF and I've got eight or nine, because my system plan's only 9 pages long.
I've got a single PDF. So if you've got the plan itself, I was looking at Planning Objective 2, pollution risk, which sets out the number of incidents. Planning Objective 9, which is the ecological issues. You've also got Planning Objective 5, which deals with the performance of the storm overflows. So it's spillages from the storm overflows we're concerned with. And then you've got at the end the generic options assessment, and it's the first 4 lines of that which are the remedying the infiltration from groundwater. So you've got that. You've also got Southern Water's own letters, which effectively are saying there is a capacity problem, but it's caused by infiltration. And the council has been seeking to identify what measures, if any, Southern Water has in place to create headroom. And Southern Water has referred to infrastructure upgrades beyond 2030, but no specific measures in relation to either minimising rainwater entering the system through drains or minimising infiltration that would be specific or detailed enough for you to rely on in order to say there are concrete measures they are undertaking which will address the problem they themselves have identified, which is that their storm overflows are operating too frequently because there is an issue with hydraulic capacity.
Okay, thank you, Mr. Moores. In terms of certainty and frequency of those events where where these storm flows take place, is there anything in the evidence before me to indicate the certainty of it other than the Rivers Trust data, which I shall come on to in a few minutes?
So exactly, Mr. Batchelor points out the Southern the Rivers Trust data is based on Southern Water's own information, so it is public data to that extent. the fact of the matter is Southern Water is saying in its correspondence that there is a problem with infiltration, which is overloading its system. They are not saying, as those letters are properly understood, that this hydraulic capacity issue will not persist. Their submission that the council frankly submits as illogical is that it's not the new housing which is the root cause of the problem. The council's simple position, though, is there is a problem, and adding more foul water to the overloaded system is contrary to what Condition 13 is seeking to do, which is only allow the development to proceed when the off-site infrastructure has adequate capacity. What the cause of the lack of capacity is beside the point. Condition 13 asks a simple question: is there capacity? And you're being told by Southern Water no. The reason no is because of infiltration and other issues related to rainwater. But the top and bottom of it is they're telling you there isn't capacity.
Okay, thank you. If I ask the appellant if they wish to add anything in that regard, and I suppose a question and I would like to ask as well is, do I have absolute certainty that were the appeal to be allowed and the scheme discharged, that there wouldn't be further or increased pollution or flooding as a result of approving that scheme?
Thank you. So, well, starting at the end, if I may. So I think the critical question is, as a result of approving that scheme, and I'll take you through the relevant points, but in our submission, by approving that scheme, you're not going to be making a problem, if there is a problem, any worse. And for that reason, I refer you firstly to the 19th of December decision, where the issue of the public foul EMO sewer, which we've covered, having been resolved, Southern Water firstly explaining they have no objections to the discharge of Condition 13 relating to foul. On the 21st of February 2024, they explained that for developments of less than 50 properties, they do not always undertake a capacity check, but in effect they would they record properties on a base model, and they will promote a growth scheme where the increased risk of flooding from a cumulative impact of new development becomes significant. Essentially, the point, sir, is when the upgrades need to happen, they are plotted on Southern Water's model, and they will make the necessary improvements. They explain in terms in the 21st of February letter that in respect of this development, the capacity would not be an issue and the developer would be allowed to connect. They go on to explain that the increased flows from the development would be minimal and would not have an impact on spills volume or frequency. So even if there is an issue with spills volume or frequency, that is not attributable to this development. They specifically also say that in respect of both Vines Cross and Horbeach WPS, the discharges there are not attributed to growth but are caused by rainwater. Again, on the 18th of March, Southern Water explained its response in greater detail, and they say there that they dispel the common misconception that new development means that there would be a greater number of storm releases. It explains that modern systems have one pipe for foul and one pipe for surface water, and it's the surface water pipe releases which release rainwater back into the environment. It also says, which we say is of relevance, sir, that storm overflows are not usually considered to be pollution. They are permitted, and they prevent flooding and pollution of homes, businesses and roads if the sewer is overwhelmed. The answer really for Southern Water is to prevent rainwater from getting into the sewer network. They've also confirmed they have adequate headroom, and this development will neither increase the frequency of storm overflows as it will not it will not cause excessive water to be added to the wastewater that causes the spills. So we say fundamentally, so whilst Southern Water might indicate that rainwater getting into the system is a problem for them, that's not a problem which this development can will exacerbate. It's not a problem which this development causes, and it's not a problem which this development can overcome. That's a matter for Southern Water.
Okay, thank you. Can I ask? I've got a couple of other questions regarding this later, so this won't be an end to it. But if an increased volume of sewage flow is being added to a pipe and network that floods, and therefore an increased volume, how does that not increase the likelihood of pollution events?
So the difference is that when you have a rainfall releases, usually if you look at Southern Water own data, you realize that there's a extremely high percentage of water which is released being just a surface water runoff. And on our development, we already have dedicated SATS feature, which is the recognized by Southern Water toll, which prevents any rainfall ingress into their public sewage system. And our surface water is completely standalone away from, our surface water is released to the stream. So it's not even being released to any form of a sewage system for which Southern Water is responsible. And in real life, also worth mentioning here is probably the water usage of modern development that is so nominal compared to the foul water, surface water flow compared from the catchment. That's the reason and logic behind Southern Water statement.
Right, I think I'll come back onto this matter later in a bit more depth.
So I could make just one very
Briefly then,
brief
yes, Mr.
comment. So firstly, the answer in relation to there being a SUDS feature in the rainwater from the site going into a separate sewer, that's effectively the misconception point that Southern Water are making. That's not the council's concern. You've correctly understood it in your question. Even if the rainwater goes off-site safely through another system, you are adding the foul water from the site to what is already an overloaded system. And the flaw in Southern Water's logic is they say, aha, it's fine because it's only minimal. But that doesn't explain why there's capacity to accept that minimal additional foul water. It's a logical fallacy. We're over capacity because of ingression. You can add some more because it's only minimal, and that won't cause an effect. And I think you have the point, sir.
Yep, thank you. I shall come back to, I shall have a few questions about that again in a little while. Excuse me. Can I just ask? I've got the foul water drainage scheme before me, the various plans. I've not engaged too much at this stage with what is some very detailed maths and numbers in the appendix. But just so I'm absolutely clear, can you explain to me, looking at the site? So I have a plan of a two-forked cul-de-sac. Can you just explain to me where sewage will, what direction it will flow, and just give me a brief indication of where it heads once it goes off site, and in what direction, please?
So off-site or on-site?
Initially on site, and then
Okay.
and then let me follow it off
Yeah.
site.
So if it helps you, we produced some blown up plans, which I've handed to my learned friend. I'm not sure if you think they're, I've only got one copy, I'm afraid. But
I will be all right.
okay, that's fine.
Okay. So the foul water is collected via gravity and follows the topography to the south of the site away from Horan Beach Lane. From there we have one dedicated foul water pumping station which collects all of the water and lifted it up back to a Horan Beach Lane via pressurized rising main.
Just stop.
Okay, so it comes down
Comes-
from the north, ineffectively similar to a V shape, or almost going.
Yes.
backwards,
So we're going, yes, so it goes, it's being collected by gravity pipes all the way down almost to the southern end of the site, from where we have a pumping station which lifts, on-site pumping station, lifts the water up to the Horan Beach Lane, so back up north, almost past the whole houses which it serves.
Yeah.
From there, it discharges into a new section of the sewage which will operate by gravity and flow towards the southern water chamber, which collects foul water drainage, and that in turn actually goes almost back south again to a Horan Beach Lane pumping station, which actually from Horan Beach Lane pumping station, there's another rising main which pumps the water from memory. It goes west and then due north before it actually turns east and
Sorry, slow down.
Yeah.
I'm just losing you a second there.
Yeah.
So from
Horan Beach Lane pumping station, which is the public Southern Waters own maintained.
the one just to the north of the site.
Yes, it's almost on. It encroaches onto the site. From there, there's a rising main, which is a completely pressurized system, so it doesn't operate by gravity, and it pushes the water first west, then. Yeah, so that's completely enclosed, and you basically pump is what gives the water ability to flow through it. And that pressurized main is going west before it turns 90 degree, goes north, and hits another gravity operated larger diameter sewer, which flows into Wines Cross wastewater treatment works, which is again actually to the east of our site.
Thank you. That's very helpful. It might not be of a great deal of technical relevance, but certainly having read the various documents, I was just trying to envisage in my own mind exactly where things go, and it seems like they do go north to south, south to north, then to the west, then to the east. Right. Okay. So that gives me a useful idea of the catchment.
And so if I could just add on that, that very helpfully confirms you've got Southern Letter's most recent letter that was submitted by the appellant. Second page of that bottom paragraph, they're confirming that there are discharges occurring from the storm overflows at the Vines Cross wastewater treatment works and the Hoare Beach waste pumping water pumping station. And so insofar as you've got something from Natural England this morning saying there's no pathway, that's incorrect, because we've just been told that the foul sewage from the site goes to those assets, and Southern Water is telling you that they are discharging to the environment.
I should have asked, where is the discharge point into the Waldron Gill? Which I think is the main. It seems to be the initial water body from where it then flows into the Cuckmere River.
So Wines Cross is its discharge point is always to the gill. Any treated water will always land up at the gill, and Wines Cross is located to the east of the gill. So any sewage has to go underneath it before they reach the treatment works, and then treated water is released back to the gill. And again, they're all due east of our site.
And where does if there are any storm outflows at the the Beach Lane pumping station, where would that go?
There is unnamed stream which runs from north to south. It originates almost at the start of the Horan Beach Lane. So literally there's a ditch which goes parallel to the eastern boundary of the site.
Right, okay, yeah,
And there is Environment Agency permit to release water in that location, and that foul water pumping station emergency overflow is what requires diversion for this development to be enabled.
Okay, thank you. And where does that stream flow into? Does that flow into the Waldron Gill as well? do you want to come back to me on that in a few minutes, and I'll proceed on with my questions. And that covers all the general matters and has given me a useful context. Thank you very much. I've got a few questions in respect of flood risk. Neither parties provided me with the flood risk assessment that was submitted with the outline application. I don't know if I need it or not. I guess it depends upon what I hear. But you've both obviously got access to it. In terms of the sewage flows, does the appeal scheme alter the risk of sewage flooding beyond what was initially envisaged within the flood risk assessment that was taken into account at the outline stage at all?
I'm really sorry, could you repeat that question, because I was focused on.
Oh,
Thank you.
sorry. There was me saying I'll give you time. We'll come back. We'll come back in a bit to Waldron Gill. Yeah. Does what's proposed in the appeal scheme, does that differ in any way to what was set out in the conclusions for the flood risk assessment submitted with the outline application at all?
So the submitted scheme mitigate the risk of any flooding on site through the provision of a swale at the western boundary of the site, which will intercept any surface water runoff, which are designated by Environment Agency as having potential of flowing through the site, and they're basically adequately diverted into the dedicated swale, which was engineered to also enhance the site before it flows south, where there's another drainage channel which runs around the southern boundary of the site.
Okay, and in terms of sewage issues and capacity and flooding, did the flood risk assessment look into that at all at the time?
The site would not be designated as being at risk of any sewage flooding, because the emergency overflow from the foul water pumping station diverts the site into that stream, which is at a lower elevation than our site. So it would not be possible for the site to get flooded by a sewage system.
And would that have been looked at in terms of increasing the risk of flooding elsewhere, which is one of the tests of the framework, and I think is required to be addressed by a flood risk assessment?
Yes, so surface water, yes, it's completely mimicked the existing drainage arrangements through the provision of SADS, and that system has been approved by East Sussex, and the only thing lingering there was the Pevensey and Cookmere, and the foul water is agreed through the provision of capacity check confirmation from Southern Water, which was obtained.
Okay, and then in terms of sewage risk, risk of sewer flooding off-site?
So that's a capacity check, which is hydraulic modeling, which Southern Water, you are not, we don't have enough information to understand and model the network which is owned by Southern Water. However, Southern Water is able to undertake hydraulic analysis, and it does actually stipulate in those letters that they do carry those out, which would recognize any points, and they actually also have actual flow meters positioned at the line of their sewage network, which verifies that the hydraulic models which they developed are true representation of what is the anticipated flows. They're matching to the readings which they get.
So perhaps for your note, there's a reference to that at paragraph 4 of the January 2025 letter, basically explaining how the hydraulic model, I suppose, ground truths what they expect to happen, because it's tested against real data.
And so what is proposed in this appeal scheme, does it you've explained to me in terms of the flood risk assessment, does it conflict with any other aspects of the outline permission at all? Perhaps I should come to the council first in that regard, but I couldn't see initially any particular other conflicts with the provisions of that outline permission. Is that correct?
I'm sorry, sir. Can you just repeat that for me?
Yeah, let me put it another way. Would I have reason to believe that the scheme would not comply with the conditions of the outline planning permission at all, or the intentions of the flood risk assessment, as was submitted with the outline scheme?
You'll have to forgive me, sir. I might have misunderstood the nature of the question. However, the substantive matter dealing with issues relating to flooding was debated during the hearing that was held for the appeal after the council had initially refused the planning permission. And whilst I can't confirm any immediate reference to issues relating to foul or not from the previous flood risk assessment submitted with that outline application, the council's view is that the substantive issue about the foul network, its incapacity to deal with the inlet of rainwater, and what that means in terms of the impacts of additional foul, were all raised, and the imposition of the condition in order to deal with that was made. So if the condition isn't dealt with in the way that the council is addressing you today, then I believe that there would be an issue with the substantive flooding matter that was raised during the course of dealing with the appeal following the council's refusal of the development.
Just to add to that, I think the way it would work is the flood risk assessment and the conditions securing the mitigation that was accepted by the inspector, that is all predicated on there being adequate capacity, and the role of condition 13 as a pre-commence or preoccupation condition is to secure that that assumption is in fact true when the scheme is delivered. So there's nothing in the flood risk assessment that answers the condition 13 question.
Okay, thank you very much. The council's case is that it seems that you're concerned there would be increased risks of flooding elsewhere as a result of the scheme. It doesn't seem to anywhere set out the magnitude of those effects as a consequence of the appeal scheme, and there's very little to give me an idea of where these effects would actually take place. Is it simply the case that there would be some increased outflows at the 2 points we've referred to, which were the two wastewater treatment works of an unknown volume, but that's the only location where there would be effects?
So that's part of the story. You'll also find from the representations made by those locally, parish council and residents, that they talk to localised flooding issues. But yeah, where there would be those discharges from the overflowing pumping station or the wastewater treatment works, and then the receiving water courses, we are concerned with regard to not only those impacts then on local residents and the human impacts of foul drainage and flooding from that, but also the impacts from what we understand to be more concentrated in terms of foul discharges from the pumping station and the wastewater treatment works, affecting initially the receiving water course, exactly where the water is received from those parts of infrastructure, and that's why we refer to specifically Southern Water's own wastewater treatment management plan for the Vine Cross, and how that identifies issues in terms of the Waldron Gill and problems with pollution and that needing to be resolved. But also why we then refer to those sensitive sites, the triple SIs that are further down the catchment area, where they identify
I'll
issues.
come on to that in a little while. I just
Fair
want
enough,
to,
sir.
purely in terms of flood risk. So you talk about the human impacts. I can't see any reference to any, for example, flooding of properties that has occurred as a consequence of rainwater ingress into the system at all.
I don't have any more information to hand, sir.
I think so. The fundamental point is we are concerned here with storm overflows which are permitted to operate in accordance with an environmental permit only in storm conditions. And the problem that Southern Water has described is infiltration occurring outside storm conditions, and therefore these storm overflows are operating more frequently than they should. One can understand why Southern Water deals with that through its environmental information team and is slightly guarded in what it says, because that is a breach of its Section 94 duty and a criminal offence. And so it's not an answer to say that this is infrequent or de minimis. It is operating in conditions that are not permitted. Discharging excrementitious matter outside an environmental permit is a risk to human health, and we say also the environment. And that's precisely the planning harm Condition 13 is there to address. If this were a Section 73 application, the argument might be, is it necessary and proportionate to have Condition 13 in these circumstances? But that's not the question here. It's a discharge application, so the question is there adequate capacity?
Right, thank you. Yes, I was just about to come to you. Shall I, if it's okay, I'll let Councillor Usborne have a few minutes, and then if I come back to the appellant on the points that the council's raised. Thank you.
Thank you very much, and apologies for jumping the queue. I have been involved with this planning application since 2019, first as a resident, then as an environmental campaigner. So this is my third appeal which I've been attending. And I have to say it was one of the important reasons why I decided to stand as candidate for Wealden District Council, witnessing what was happening to residents. As a ward member and indeed a resident of a very close by village, I was physically involved in the effects of foul flooding and surface flooding. As a historian, we talk about social history, the lived experience, and eyewitness accounts. So if I could just base my deposition to date on a letter which the owner of Old Orchard House wrote to us Wealden Green Party members, but also to me as the ward member, and indeed to his MP Nusrat Ghani. The letter is from the 30th of October 23, and what he sets out is how his house and his neighbors have been suffering, in fact, from at least November 2020, both from wastewater but also from surface water, which he says really started getting much worse since the Rosemead development, which is opposite his house in 2016. So in November 2020, he said wastewater backed up to within a foot of entering our downstairs shower. It prevented us using any taps, toilets. In October, there's quite a bit in between, October 23, 16th of October, he says, my son reports that he cannot flush the toilet and that the shower is making strange noises. I'm away on holiday, but I'm in contact with Southern Water. Thursday morning, the evidence is clear and he submits photographs. Raw sewage actually backed up into our garden and into our house. And that it did again on Friday, the 18th of October. Again, he shows videos and photos. So they can't use the toilets. The raw sewage is in the garden. It's in the house, just under the floorboards, in a bedroom that has an inspection point under it. The whole house smells and is damp. So he goes on, and as soon as I heard this, I made my business to see what was happening. I talked to these people. 4 huge lorries were contracted to pump out from the pumping station in Horbeach Lane day and night. They were very nice chaps. They came from Romania, all of them, hardly spoke English. They said, I'm so sorry, this is a terrible job we're doing. Then I got complaints from residents of Rosemead who were also flooded, but they said the worst thing is the noise of this pumping going on day and night. The children couldn't sleep, etc. They also complained about the danger of these lorries going through a relatively small road in the morning when they go to school, trying to dodge cars coming towards them, going on the pavement. So the whole neighborhood has been terribly affected. And I think I just want to bring that human experience to your attention. Thank you.
Okay, thank you, Councillor Osborne. Can I ask the appellant, that was, in some ways, that was delivered whilst we were discussing the matter, so quite useful timing. So, because I asked the council about incidents of flood risk, Councillor Osborne has set out a couple of accounts there dating back from the 2020s. Is there? I've not been given any formal records of them. Would the appeal scheme exacerbate an impact on Old Orchard House in particular, as a result of the further?
So, generally speaking, I'm really surprised that Old Orchard House could suffer from flooding. Once you go on site, it will be quite evident for you where our site is and the level difference. And, okay, pumping station is actually downstream of Old Orchard House, and Southern Water.
Sorry, I'm working it out in my head.
I can show you.
Station is downstream. Right, okay.
So
yeah,
I'm looking at the topographical survey over here of the site. You'll see once you go there. So Old Orchard House is first house adjacent to the land at which we're building.
Yeah.
We will be building completely downstream from Old Orchard House. There's no chance, unless we create a massive error in construction and put a rising main into his drains, onto his properties.
That will be a big error.
That would be a big error. But also, the topography of the site is not shifting. So to hear an account that Old Orchard House could have a back garden flooded, once you be on site, you realize that from my engineering mind is virtually extremely difficult to achieve, because the water always takes the easiest route out of the site, and the easiest route out of the site from Old Orchard House is actually to enter our site simply by the virtue of gravity. It wouldn't really exacerbate. Not completely aware that Southern Water had a problem which resulted in any form of tanking. Why would emergency overflow not has been used or being in use, as it's being stated that it's being used a lot? So why all of a sudden it failed, where our client has not been notified that they have to carry out any works to the EMO to rectify a problem. Again, and Rosemead Farm, which is on opposite side of the road to the north, yes. Again, once you be on site, you realize that its topography, our drainage ditch on the east of our site is the natural receptor of surface water flooding from the Rosemead development or anything up, because they're uphill of us. So Rosemead, again, I really would question whether someone from development, which is 3 years in operation to the north of us, could really suffer a foul water flooding in any event, because you will see once you're on site that they are at considerably higher elevation. So if there was a fail malfunction of the pump and fail overflow, I would still say that gravity would act on any water lifting chambers within the road will be the first escape route for the water. And from memory of visiting the site on a few occasions, I doubt that any of the new development which is built a couple of years ago could really suffer foul sewage flooding, unless there is a blockage in the system which was caused on site, the same as there could be a blockage. There was no account what caused the blockage on the old Orchard House. Maybe it was their own drainage system on site, being just old house that, you know, something collapsed. But Southern Waters does not provide us with any incident report. And when we designed the drainage system, we had extensive consultations with East Sussex drainage team, for instance. That's the reason why we're on revision C, to address any additional comments or query which were raised about the design. And only once the lead local flood authority, being East Sussex, and actually Weldon District Council drainage officer, countryside officer, Graham Keane, were satisfied, there any objections to build this drainage system were removed. And shame about the lady, she had to go, but again, she made a statement that she witnessed and was acting on sewage flooding in the area. I personally produce, I don't even know how many flood risk assessment in the area, and they all tabulated always as a publicly available data, which are parts of strategic flood risk assessment for the areas.
So they would have so as a matter of course it should have captured any incident.
So flood risk assessment produced for this site or any subsection site in this area would always capture and comment about the flooding of sewage system or surface system within given catchment of the site.
And that wasn't recorded in the 2022 flood risk assessment?
I don't recall seeing that.
Sorry, Councillor Lane.
Oh, can I just add on one extra thing? We
Yeah,
talk,
sure. Then I'll come to Councillor Lane.
we'll talk about Environment Agency permit for Waldron's Gill and even the foul water discharge point from the pumping station. From my involvement in different scheme, if there is a breach of the environmental permit, like for instance, even on that site, one of the problems which we thought we'll have to face is to apply for new environmental permit for relocation of the outfall, because outfall from the pumping station at Horan Beach Lane is highly regulated. And Environment Agency monitors those outfalls to see if they are within the limit of what they grant to Southern Water. And from my professional opinion, if those would not be compliant with Environment Agency permit, Environment Agency issues non-compliance notice to whoever holds the permit and gives to agree the time frame, which is relatively quick, and there are hefty penalties involved for any person holding the permit to rectify problems.
And so you're suggesting that there's been no
Southern Water has not come to us and said that there is a problem on environmental permit or they were issued non-compliance notice, but the fees which Environment Agency charges, I would say they would make, from professional experience, considerable dent into their budget because they are expanding quite rapidly. So if one day you pay £1,000, by the week two, if you have not fixed your problem, it's £2,000. By week three is £4,000. So they sort of exponentially grow.
Okay, right. Thank you. Councillor Lane.
I'm sorry, I just wanted to draw your attention.
You say tankers permanently. What are we talking? Frequency?
Because you will see the amount of detriment has come through and it flows into the Putney.
And this is the Beach Lane pumping station. Yeah.
Discharges into the Putney.
And so just to note on that, the inspector who imposed condition 13 had Horham Parish Council's 22nd of June 2022 letter of objection, and the final page, it's internal page 7 of that, referred to the Horbeach Lane pumping station, councillors reporting having seen sanitary products and condoms during a site visit. Subsequent inquiries show that Southern Water have documented 39 separate unauthorised discharges from this one pumping station, totalling 177 hours of discharge, and the source of that information was Southern Water's website and a Freedom of Information request from Wealdon and Rother's public health team. So that was the evidence he had when he imposed condition 13.
Sir, if I may just come in here, what you don't have is any evidence whatsoever that those issues are associated with this development or any other development. And to that point, the Southern Water problem characterisation assessments at the Vine Cross treatment works, if you look at figure 2 in that document,
Was this the one that Mr. Malls referred me to earlier, the system plan?
because what that document does is identify a number of different potential causes of issues. Now, absent again from that list is development.
Okay, thank you, Mr. Best. Can I just ask the appellant and then the council, can you just confirm where it's set out what the estimated volume of sewage generation per minute, hour, week, day, whatever the appropriate measure is set out in the submissions?
Sorry.
Yeah, where is it set out the increase in sewage generation that would occur as a result of this development in the evidence? And can you just point to me, does it give a weekly, a daily, an hourly average rate? Yes, just as a result of these houses.
Yeah, so Southern Water would calculate the water usage. There are generally, these days, Southern Water is still using one of the highest unfactored water usage, generation of sewage, which is 4,000 litres per dwelling per day, which is extremely exacerbated because for the houses which have to now be water efficient, if you calculate in real life, you are not even reaching 1.5 cubic meters. But for their own hydraulic model, Southern Water usually use 4 cubic meters of foul flow per day, so per 24 hours per household, and they take into account intensity of a morning peak flow and evening peak flow rates. But in real life, that figure is even, they recognize now that it can be much lower. The industry good practice would say that they can decrease the figure from 4 cubic meters to 1.5, 1.7 cubic meters per household. But they still use much higher just for safety and what is approved.
Okay, so 1,500 litres or 1.5 cubic metres
Is
per
per-
24 hours of,
per dwelling.
foul water,
Per
effectively.
dwelling, yes.
Per dwelling.
Yes. That's what most, even if you go and you would ask any of the pump manufacturer, any of the control body or building control, once you're calculating the storage storage capacity, they will all calculate based on that figure. But if you look at the code of old sewers for adoption, the value is 4 cubic meters per household, so it's much greater.
Okay, that's very useful. And are you able to give me any form of quantification of what that 38 times 1.5 cubic meters looks like as a proportion of, say, what flows through the Horbeach Lane pumping station, per 24 hours? So
Pumping station, from my calculation of the catchment, what I did is obtain sewage record which shows number of property that are connected into Horbeach Lane pumping station. And I'm talking from memory, but I think is in total 186 is existing property number which connects into Horbeach Lane pumping station. And if you think that 186 times 1.5 cubic meters per day, but the problem with it, which is worth mentioning, is that some of those houses are most likely are in the process of having mismanagement of surface water. This is what Southern Water recognized. They're supposed to get rid of surface water through other means, i.e. rainwater garden or implementation of SADS features, whereas there's always mismanagement and people connect.
okay, so because of their age, they will have a shared pipe that discharges
Or
foul
even
and
when
surface
people
water?
do some works to their property, sometimes people just connect to the nearest drain. Especially older properties, they will do that.
Okay.
So it's called mismanagement. Like, even when you do calculations for a new drainage system, you always allow for mismanagement. Southern Water ask for the size of development for that reason too. They also take into account the additional flows which will end up in their sewage system as a result of misconnections. I don't know if it's worth noting, but by conclusion which can be drawn, there is another planning application on the opposite side of the road, Rosemead, like a phase 2 of Rosemead, which is, I think, for 60 units. And from what I have seen on Wealden District Planning Portal, Southern Water has confirmed that they also have capacity for that further 60 units to be treated. And it's inevitable that this is the control point. The same pumping station will also go into that treatment. So I would say they are confident that they have spare capacity.
And that will go to Horbeach Lane.
Pumping station, and from there it would go again to Vines Cross wastewater treatment works.
Okay, thank you. My final question in terms of flood risk is, I should obviously deliberate about what I've heard, is can I conclude that the proposal would be compliant with the reasons for conditions and paragraph 181 of the framework in respect of not increasing flood risk elsewhere?
Yes, we are confident that that was the purpose of this development and the way how it was engineered in terms of drainage to be compliant. And as engineering practice, we operate, and being chartered engineer, I have to be also adhere to a standard of institutional civil engineers, which if I notice something is wrong, I supposed to act on it in the first instance with my client. But if I cannot reach a mutual agreement that satisfies me, I supposed to go in to either ICE or just decline the work. So there's a standard to which you have to uphold, and East Sussex lead local flood team, they are also chartered engineers. So the checking body is also chartered.
Okay, thank you. I would ask the same question as I've asked the appellant to the council, but it would also be useful to, if I could just ask you, is it significant, or should I have any regard to the fact that the lead local flood authority didn't object to the scheme at all as the council's advising engineer?
No, sir. They would be focused on surface water. There's no indication that this is an issue they've considered.
Compliance or otherwise with paragraph 181 of the framework in respect of not increasing flooding elsewhere?
Well, obviously the crux of the council's argument is that there would be a conflict. What you've heard is that there would be an increase of 38 dwellings connecting to a pumping station that deals with 186, so that's a 20% increase. That's more than de minimis. This isn't a case where you have calculations showing you existing capacity and headroom and then determine whether the 38 houses will generate more foul discharge than the system can accommodate. In the council submission, you have letters from Southern Water showing a lack of capacity at those particular pieces of infrastructure. The addition of 38 times 1.5 cubic metres is more than de minimis. And so contrary to the requirement of condition 13, you can't be satisfied that there is adequate off-site capacity to appropriately either prevent flooding, flood risk elsewhere, or deal appropriately with pollution. And I think it's fundamental to understand that the council has, through its letters to Southern Water, only been seeking explanation, logical explanation and demonstration that capacity exists. You read that chain of correspondence, it's quite clear what the council is doing is seeking to understand the bare assertion that this is all fine. That's not been provided, and the figures have just been explained to you explain why there is a material contribution that this site would make to the foul water dealt with by that pumping station.
Thank you. Did the appellant want to say anything finally before I move on to pollution?
Yes, only a couple of points, sir. You have repeated reassurances from Southern Water that there is headroom and that there is capacity. You would need cogent and compelling reasons to depart from that, which we say the council have not produced. They're just asserting that there is no further explanation, but Southern Water are clearly experienced and should be trusted as the advisors of the council on this issue. As to off-site capacity, Southern Water have repeatedly explained that the issue is to do with rainwater. They say that the council should ensure that there's no impact of rainwater going into the sewers from this development, and as we've explained, that won't happen. Surface water will be managed appropriately and will be prevented from going into the sewer network. So we say insofar as this site can control that issue, it does so. I think that was everything. There's anything else?
Sir, the party best placed to advise you as to whether the flow is de minimis and whether there is capacity isn't the council, it isn't the appellant, it's Southern Water, and you have repeated correspondence from them confirming it is de minimis and there is capacity.
Matter. I'll start with the pollution, and it's probably a linked issue to some extent of what we've been discussing so far. I noted the letter in Appendix A of the appellant's appeal statement. Can you explain, and it refers to paragraph 201 of the framework. Can you explain to me, does the Water Industry Act itself, which Southern Water is bound by, does that constitute the control of a process or a pollution control regime?
Difficult question, sir. But
That's why I asked it.
I think the Water Industries Act is, I think, a pollution control mechanism, and one upon which you should place a great deal of weight, as other inspectors have done in the past. And you'll have noted in the appellant's appeal statement a number of decisions, one of which was in West Wittering, where Inspector Anne Jordan explained that in terms that reliance should be placed upon other regulatory regimes and that they should be assumed to be operating effectively. Plainly, Southern Water are governed by Ofwat. There are some other points I'd make about.
Yeah, sorry. Could you just the appeal decision at West Wittering? What appendix number is that?
Yeah, she says in terms that there would be no compelling basis to treat sewage arising from the proposal or suggest that the scheme would lead to any repeat unlawful activity. She noted that should Southern Water fail to meet its obligations, then Ofwat is obliged to take appropriate action and to ensure the necessary work is carried out. And we say so that's a correct statement of the regulatory position and the one which you should similarly adopt in this case. There are other examples given in the appellant statement too, but I need not.
Yeah, I've got a couple of questions regarding those in a bit. You mentioned Ofwat. What significance are they to my consideration? I appreciate they are the regulator of Southern Water and all of the companies under the Water Industry Act, but what assurance or otherwise would Ofwat give me?
Well, I think, so your starting position is obviously the framework, paragraph 201, which says that you should assume that other regulatory regimes will operate effectively. And we say so that the interrogation of the processes or emissions, which are the subject of a separate control regime, through this appeal is precisely what we're not supposed to do. And so relying upon Ofwat stepping in to regulate Southern Water, if they're not doing what they say they're doing or discharging inappropriately, is exactly what we say should happen. And you've obviously heard an explanation already about the role of the Environment Agency too in controlling outflows.
Are the agency regulators or an authority under the Water Industry Act, or is that in terms of the environmental permitting regime?
The latter, sir.
And so, as a matter of course, the Southern Water have an environmental permit for the Horbeach Lane pumping station, and that is monitored by and policed by it's monitored by Southern Water, but policed ultimately by the Environment Agency, and that's where Mr. Wojciak, you referred me to the escalating
Yeah.
some of the
Yes.
escalating fines.
Yes, so if you go on the public domain, there are different location upstream and downstream of the Waldron's Gill, at which Environment Agency monitors the water, and also at any treatment facility they must have their own sampling chamber, which most likely automatically collects data for Environment Agency.
Okay, thank you. The council.
Thank you, sir. Dealing first with the regulatory regime, Ofwat and the Environment Agency, the fundamental point is that a Barrett-type condition doesn't cut across what the framework says about having regard to other regulatory systems. A Barrett-type condition is imposed specifically to deal with what I termed sequencing. So you'll see this explained by the Supreme Court in Barrett, paragraph 43. They say the Court of Appeal suggested that the practical answer to this problem, that's the problem of the absolute right for a developer to connect to the public sewer, lies in the fact that the building of development requires planning permission under the 1990 Act. The planning authority can make planning permission conditional upon there being adequate sewage facilities to cater for the requirements of the development without ecological damage. If the developer indicates that they're going to deal with the problem by connecting to the public sewer, the planning authority can make planning permission conditional upon the sewerage authority first taking any steps necessary to ensure that the public sewer will be able to cope with the increased load. Such conditions are commonly referred to as Grampian conditions. Thus, the planning authority has the power, which the sewerage undertaker lacks, of preventing a developer from overloading a sewage system before the undertaker has taken steps to upgrade the system to cope with the additional load. So the point is that there is a system under the Water Industry Act whereby there's a Section 94 duty for an undertaker to effectually drain their area. That includes complying with the urban wastewater treatment regulations. There's a process where, either through enforcement or through the price review mechanism, Ofwat can authorise or compel infrastructure improvements. The infrastructure is permitted, and that's policed by the Environment Agency. But the planning system performs a legitimate role, as the Supreme Court has explained, in terms of sequencing. The Water Industry Act will deliver the infrastructure upgrades and environmental permits will be policed, but the planning system can, via a Barrett condition, which is what we're dealing with here, hold development back until, through the Water Industry Act, sufficient capacity has been provided. So it is the two regulatory systems working in tandem, doing precisely the thing that the Supreme Court said they could and indeed should to deal with the problem created by the absolute right to connect. The reference to Appendix C I can just deal with very briefly. If you look at paragraph 91 of that appeal decision, you'll see Southern Water explained that there was capacity at the Siddlesham wastewater treatment works in that case. And so the inspector concluded that there wasn't evidence of an off-site capacity problem, so he didn't impose a Grampian condition. Well, that's not this case. The inspector who considered the outline application did have an objection from Southern Water, he did have an objection from the parish council, and he did impose a Grampian condition. All of my learned friends' submissions should have been made at the outline stage as to whether that was an appropriate condition or not. The fact is it's here. And much the same can be said of all of the other appeal decisions and documents. I can canter very quickly through all of the appendices and give you a sentence on each one if that would assist you.
I've got specific questions.
I'll deal with them as suits you, yes.
In a little while on some of those. So coming back to the the Appendix C decision, and I think the Appendix D one raises a similar issue. So, in terms of this appeal scheme, there was an objection by Southern Water, and therefore the inspector imposed the condition. Now there isn't an objection by Southern Water. Does that change? Does that change things at all? I appreciate the condition still exists.
Well, indeed, and the position ordinarily would be you would give significant weight to the views of a statutory consultee and of Southern Water on this issue. But their position of no objection frankly didn't make sense to the council, and so you have the subsequent exchanges. And as we've set out in our statement of case, and as I've explained in submissions so far, what you should take from those documents is an admission there's a capacity exceedance and an illogical reason for concluding that satisfactory capacity exists for this development. All that's said is the main cause is infiltration, and the addition of foul water from this site would be minimal. None of that goes to show that there is headroom or capacity. They say we don't carry out an assessment for fewer than 50 dwellings. You're proposing fewer than 50 dwellings, so therefore it's okay. It's paragraph 42 of our statement of case, just sets out in a number of bullet points what the logical fallacy there is. So there have to be cogent and compelling reasons for disagreeing with the views of the likes of Natural England and other statutory undertakers, statutory consultees. But here in my submission you do have them, the basic logical flaws that the council has been pointing out.
Okay, thank you, Mr. Moores. If I give the appellant, did you want to say anything further in respect of it was in respect of the Barrett type condition and judgment, and there in respect of the Appendix C scheme as well?
Yeah, I've obviously been through the facts of that case already, sir, but yes, we accept, as a point of principle, a Barrett-style condition can mean that upgrades are required in certain cases, but in the Barrett case, that was to do with the developer connecting to the sewer and where that connection should take place and who should pay for it. What we have here is substantial evidence from Southern Water explaining that those are not issues in this case. And just by way of example, if you turn up page 34 of the pack of letters, we can see that Southern Water they say they've looked at ways to slow the flow, and this includes the installation of SUDs, e.g. planters, rain gardens, swales, digitising their sewer network to better monitor and control flows and help to optimise capacity, assessing the structure of the network, looking at where parts of it need to be upgraded or replaced, and educating the public on small-scale solutions to help reduce the pressure on the drainage system through the use of water butts and recycling rainwater to reduce the amount of pavement in gardens. I mean, with the greatest respect, sir, those are not issues which this developer can have any influence over or control. They're not relevant to this development. This development's put in place SUDs. It's assured the local planning authority that it won't discharge to the sewer. Different case to Barrett, where the issue was, can this development connect to the public sewer or not? And we say it would be demonstrably unreasonable to require those types of holistic measures, if I can put it that way, which Southern Water have explained in their consultation response, to be required before the discharge of this condition, where Southern Water have repeatedly explained there is headroom, there is capacity. Rainwater is the problem, and there is nothing that this developer can do about that. Just, do you want to come in?
Yeah, and if you read
So finally, I think from our side, the argument the council seeks to make in relation to the Supreme Court ruling has already failed in the mind of one of your colleagues, because it's addressed in the Clappers Lane decision, which is Appendix B of the appellant's statement. And if you read paragraph 48 of that decision, it gains absolutely no traction.
Funnily enough, my next question is, when the council made representation to the appeal in Ref Clappers Lane, at paragraph 48, the inspector considered there were different legislative powers in Wales to England in respect to the Water Industry Act. Is this correct? And what does it affect the relevance of the Barrett judgments? Your view, the appellant's view, Mr. Best, is that it does affect their relevance. Is that correct?
I'm not sure I can give you a confident answer on that, sir, but insofar as Barrett is relevant, I think we've more than explained why, in this case, there is just no evidence of such an issue. If there is an issue, it doesn't arise from building houses in this location, and it's not a problem that this developer can deal with. I think that's...
Say anything else on Barrett before I move on from it?
Two very quick points on Barrett and Appendix P, Clappers Lane, if I may. So Barrett, the point about Wales being different, I think that arises from paragraph 43 in the Court of Appeal, and there the Court of Appeal referred to there being policy in guidance in Planning Policy Wales March 2002, which required local planning authorities to take account of infrastructure capacity and effects on existing local communities and the environment. So in other words, the policy in Wales that justified the imposition of the off-site condition was peculiar to Wales. So the inspector at Clappers Lane was quite right to say, he was dealing of course with the question, should I impose this type of condition? And he quite rightly said, well, if I'm going to, I've got to have some different reasons than planning policy for Wales. Looking at what he actually did in the case, you can see at paragraph 43, the local authority had raised a concern about sewer capacity. Paragraph 45, Southern Water said capacity improvements would be needed to connect to Clappers Lane, but the appellant then identified two other possible connection points, and the inspector accepted that connection would be possible at those two other locations. Paragraph 48, he correctly distinguishes Barrett in the sense of it doesn't answer the question, should I impose this type of condition here? He didn't do anything to question whether it's an appropriate planning condition to impose in England. It's just there needs to be a different policy basis for it in an English local authority area. He distinguishes at 49 various appeal decisions that were cited to him. And then at 50, in the actual result of the case, what he did was impose a Grampian condition to prevent occupation until Southern Water had confirmed that there was capacity on the site, and that's condition 22, which you see at internal page 29 of the decision letter. So that condition that he imposed had the same practical effect as the Grampian, with the condition imposed in Barrett, and all it shows is that was a fact-sensitive decision as to whether to impose a condition dealing with off-site capacity in the first place, and the fact is he did.
Okay, so there was no. So you'd put it to me, there was no issue in terms of a national planning policy basis.
No. It's an example of in England a Grampian-style condition being imposed, preventing occupation until adequate capacity has been demonstrated.
So are those circumstances now different to the proposition that is before me, where Southern Water are saying there's no issue?
Well, the position here is Southern Water did say there was an issue, and so the condition was imposed. And the question for you is a different one. It's, is there evidence before you that there is satisfactory off-site capacity? Southern Water have said they don't object, and the council has asked them to explain that, and for the reasons we've gone through, their response doesn't satisfactorily answer the question. So it's important not to row back, as effectively the appellant's submissions seek to do, to either argue what the effect of condition 13 is. It's patently clear it's a Barrett-type condition encompassing off-site issues. It's the same words, and it was responding to the objections I've taken you to, including from Southern Water. I mean, if effectively to say that condition 13 doesn't deal with off-site matters, you would have to conclude that the inspector failed to give any reasons for disagreeing with the objection of Southern Water and the parish council, which squarely raised that matter. He quite clearly, in paragraph 35 of the decision letter, thought that condition 13 was the appropriate answer to the concerns that had been raised.
Okay, thank you, Mr. Malls. Did the appellant want to come back on anything in respect of that specific circumstance in the question before me?
Yeah, just a couple of points. So obviously, in the decision that you referred to, the question was basically hold the development back until Southern Water, till the undertakers confirm they have capacity. The evidence before you is that they do have capacity, as has been repeatedly explained. And then just a second point of context. When the appeal inspector determined the previous application, at that time, the position of the public foul sewer, the EMO, was crossing the site, and that's obviously since been moved, which has led to the switch in position from Southern Water from a point of object to a position of supporting. That's correct. Yeah.
Yeah, but we could also add here.
Sorry, that diagonal line that's on the plan across the site is no longer there, and that's what you're saying has caused the change.
No, I would elaborate a bit. So, the Southern Water was objecting to this development on the grounds of this diagonal line being there, and it would impossible to build this development. But also, back when they were consulted at the planning stage for this development, whether it should go ahead or not, they haven't carried out capacity check. They have only did basic desktop study to see if there is capacity available or not. And hence, if you read, it says there might be a risk of flooding as a result of this development. Whereas once they were knowing that the developer is committed to build on this site, then the application was made to divert that diagonal line, which is through Southern Water, their own team. Then they did also carried out capacity check to verify and confirm adequate capacity available within the system to accept the foul water flow loads from this development. So that's the timeline basically, and that's everything.
Okay, thank you for clarifying that. I think I've got two more questions now, and then we'll adjourn for lunch. I'd like to deal with Appendix E and F appeal decisions whilst we're on a roll in that regard. In respect of the Appendix E scheme, is the specific concern in respect of the existing capacity by Southern Water expressed to that application different to the circumstances before me now? If I come to the appellant first.
Sorry, so I'm just trying to bring up Appendix E. Right, so is the situation different?
Yes. To the situation that's before me now, or is it similar?
Well, both developments would logically connect into the same wastewater treatment plant, so that's exactly the same. In both developments, Southern Water say there is capacity, and it's worth noting that the land east of Rosemead decision post-dates the council's refusal of this application. Undoubtedly, there will have been a discussion, if nothing else, due to concerned neighbours at the hearing where this appeal was allowed regarding surface water, regarding foul sewerage, and yet the inspector, in the knowledge that the council has refused this development, has still seen fit to allow the appeal. So no is the short answer to your question, sir.
Right, Mr. Moores.
Thank you. Just a very short point. Paragraph 29, the inspector says, proposals supported by adequate information to persuade me that proper foul and surface water drainage can be achieved via detailed design and dealt with by condition. And then you look at the conditions he imposed, internal page 10, condition 12. It's in 3 paragraphs. If you look at the second paragraph, foul drainage system shall be implemented in accordance with the approved details and, prior to occupation of the development hereby permitted, confirmation that there is capacity within the associated drainage network will be submitted to and approved in writing by the local planning authority. So what that shows is, on a site 150 metres away from the appeal site, last year the inspector thought it was necessary to impose a condition requiring adequate capacity to be demonstrated before occupation. So it shows, A, that in England, Barrett-style conditions are perfectly appropriate according to national and local policy, including local policy in Wealden, and B, that as the facts were presented to that inspector last year, he thought there was an evidential basis for requiring that as a pre-occupation condition. So it's a case about whether you should impose a Barrett condition, but the fact that one was imposed is consistent with the council's case here, that there is a problem and reassurance needs to be provided.
So the key point is that the inspector wouldn't have been able to impose that condition had he considered it to be unreasonable, i.e. there's no prospect that you could discharge that condition, and he made that decision in the context of the council's decision to refuse the application that is the subject of this appeal.
Well, that's precisely the point. It's a reasonable condition to impose. The evidence is that the issue is principally caused by infiltration. That can be addressed by the undertaker doing something. It's not the council's case that it's impossible to demonstrate there is capacity. The council's point is it hasn't been demonstrated yet. Undertakers regularly undertake improvements to sections of pipe to prevent infiltration. If this were a case where the only solution were infrastructure upgrades that are going to take place beyond 2030, then that would be a valid point. But the problem has been diagnosed as infiltration, and there's no evidence that there's nothing that can be done to address that any sooner. So it's a perfectly reasonable planning condition to impose. In my submission, exactly so, sir. The position is that at paragraph 36 of the decision letter, the Secretary of State relied on that joint statement and the creation of not only the water credits market, but also other water sustainability initiatives, and based on that evidence concluded there would be headroom for the development, and therefore there was no need for a pre-occupational pre-commencement condition.
Do you agree with what I said, Mr. Best?
Well, it's hard to disagree with it on the face of it, sir, because it's very obviously true that there was a water credits market. I think what the appellant is getting to, I'm just looking back at what we said in our appeal statement. The council asked the Secretary of State to consider whether it would be appropriate, alongside those water efficiency measures, to be secured through a final draft planning conditions. Then firstly, this is paragraph 3.15 of our appeal statement, to manage the additional demand on water resources arising from the development proposals by delaying the occupation of the development until 2032. And ultimately the inspector concluded that there's no need to do that. And there was no need to link it to delivery of strategic water intervention measures either.
Okay, thank you very much. Both. Did you want to say anything more,
Sorry,
Ms.
sir, there was-
Davies, before we adjourn?
Just one short point on the interpretation of condition 13. We've heard a lot about it being a Barrett-style condition, as we've explained, where there is an expectation that off-site works be undertaken. But properly read, condition 13 just indicates that the development approved by the permission will have a scheme for foul drainage submitted and approved by the LPA. It doesn't say it needs to deal with all of Southern Water's problems. And in my submission, that is an unreasonably expansive interpretation of condition 13. Just thinking about the tests that condition would have needed to have met when it was imposed by the inspector in this case. Firstly, is dealing with off-site issues to do with the statutory undertaker relevant to planning? No, sir. Those are relevant to Southern Water's role as a statutory undertaker. Are they reasonable? In my submission, sir, no. That would be to ask this appellant to bear the cost and burden of cleaning up Southern Water's operations, to which it will not contribute on any of the evidence. The condition is sufficiently precise. It's not for us to impute into that condition, wider considerations of what's going on in Southern Water's network. That's not what the condition is doing. So to read into that condition that we need to kind of look beyond the site, look to issues which don't concern this development, is, in my submission, an unreasonable interpretation of the condition, and one which frustrates its natural and ordinary meaning when considered against the relevant case law on how to interpret conditions.
So if I may respond to that, that is wrong for three reasons. Firstly, as I said at the outset, it is materially identical wording to the condition at paragraph 19 of Barrett, where the Court of Appeal and Supreme Court made clear the effect of it was to control, among other things, off-site capacity. Secondly, the condition was imposed, for the reasons in DL35, in direct response to an objection from Southern Water seeking a Grampian condition dealing with off-site capacity, and the objection of Horham Parish Council raising off-site capacity issues. The inspector gave no reasoning in the decision letter to say it would be unnecessary, unreasonable, not for a proper planning purpose to impose such a condition. So you're being invited effectively to conclude that the inspector disagreed with Southern Water and Horham Parish Council, yet provided no reasoned explanation for that in his decision letter. far more convincing explanation is that condition 13, in the same words as Barrett, was responding directly to that complaint and quite properly treating it as a matter that went to conditions rather than the principle of development. And then the third point is we've just looked at the land of east of Rosemead, where a condition has been imposed explicitly in a Grampian form, requiring satisfactory demonstration of off-site capacity. That's a site 150 metres up the road and a decision from last year. So it cannot be said that these types of planning conditions are unnecessary, unreasonable, and not for a proper planning purpose. All that the condition, it was condition 12 in land of east of Rosemead does, is expressly refer to off-site capacity. That's a distinction without a difference. The Barrett condition didn't use the words off-site capacity, but it was construed as having that effect. And Southern Water, you'll recall at the outline stage, were asking for a Grampian, and what they got was condition 13. So really the appellant's argument here is either that decision was wrong, or in light of the circumstances now, condition 13 should be modified or removed. But that's outside the scope of this appeal. And to dress that up as an argument about the construction of condition 13 is wrong for those three reasons.
Two very, very short points there. Obviously in Barrett, those were issues which were within the gift of the developer. We're arguing about which manhole we connect to. That's not the case here. There was very, very much a concrete solution, if I can put it that way, in Barrett. You're either connecting to one manhole or you're connecting to another. That was within the gift of the developer to resolve. So yes, it might have considered some off-site issues, but they weren't other downstream, unrelated to the development issues. They were plainly directly relevant to the issues in that case. And then just on the appeal decision, you were taken to paragraph 35, and that's where the inspector provides their justification for imposing the condition. Again, it doesn't say anywhere there that we should be looking to off-site issues or issues with Southern Water more generally. And of course, when reading paragraph 35, it's essential to remember that that was in the context of there being this outstanding issue with the EMO and the way in which the drain was moving across the site.
Yeah,
Had to be moved, yeah.
And to answer a completely different question which you asked earlier about the outfall from that stream, which is on the side of our site, on the east, which is the recipient of the EMO overflow drain from the Horan Beach pumping station. This goes into Cookmere River. It doesn't go into Waldron's Gill.
Okay. The Waldron Gill goes into the Cookmere River.
Just one very short point. So you've been taken now twice to this issue about diverting a sewer across the site. That was not the reason Southern Water was seeking a Grampian. It's quite clear reading their 14th of February 2022 decision. They talk about the sewer diversion and they move on to the separate issue of capacity and set out their desktop study and the concerns it gives rise to. And they say Southern Water hence requests the following condition to be applied. Occupation of the development is to be phased and implemented to align with the delivery by Southern Water of any sewage network reinforcement required to ensure that adequate wastewater network capacity is available to adequately drain the development. They're saying there in terms that they want a Grampian condition because of capacity reasons. It's got nothing to do with diverting a public sewer across the site.
Right, okay. Thank you very much. I shall take an adjournment for lunch in a minute. Is 13:10 sufficient time to be back here? Okay, in that case, we'll see you all then. The hearing is adjourned. The hearing is resumed. For the amendment, question. Ask the appellant, does the government or the regulator permit a sewerage undertaker to discharge into surface waters? And if so, what are the circumstances under which this is allowed, and when is it not allowed?
Okay, I don't really know the answer 100%, but what I can tell you is that a regulatory body would permit, first of all, always a discharge of treated effluent into surface water, absolutely fine for any sewage undertaker. And they would have a specific, almost bespoke for each of the site permit about emergency sewage system dumping. So it will be case by case. If the system is, let's say, designed to operate only in a foul sewer only scenario, so there's no combined system, I would say there would be extremely stringent rules in place for that system to ever be allowed to dump raw sewage in, unless there's a problem with sewage system also known as a stall flow, basically. So what's happening is, if you imagine that the base flow is not enough, sometimes you could have the problem of sewage treatment works can sometimes face, there's not enough water for them to be able to treat the effluent which comes in. And then they sometimes have to use emergency spills to release the water to be able to operate. But in their definition, I don't think they designate this as a pollution. But when it comes to any form of proper incident of emergency spills, they always designate it as to prevent a risk of flooding to a property. And they, from what I understand, always try to say that 96 to 98% of the spilled water is still being screened. So it's not a raw sewage with excrement and stuff like that going through. It's literally just water going through, which is heavily diluted because of the rain which goes into the system at the same time. But the undertakers would always argue that before it's being released, it always passes through several screens which prevent anything which shouldn't really exit the site anyway to reach the environment.
Thank you. And does that include for the Hall Beach Lane pumping station?
Yes. So as I mentioned before, it became apparent when Southern Water has disclosed to me that if we try to move the outfall from the emergency overflow, this would automatically trigger a need for a new permit to release, to have emergency release from that site, not from the site, from that pumping station. Whereas if we modify the drainage system in the way to keep existing outfall, we'll still be completely compliant with existing permit which is in place. So for this conclusion, you can basically say yes, that both Horan Beach Line pumping station has its own environment permit to discharge into the stream which is there, and by virtue I would assume that being so much bigger, the Vines Cross must have a complete monitoring of Environment Agency.
Okay, but a similar sort of basis, effectively.
Yes,
but just to the
larger scale, and probably like on the Horan Beach Lane, there's no sampling chamber as far as I can see from the existing layout. I'm fairly certain that, like, if I design drainage system which operates via treatment plant, downstream of the treatment plant, you always have to have a sampling chamber which is accessible, so that EA, if they issue a permit, they can go and sample the water at any time. Whereas on a most likely on something like a wastewater treatment works, they'll have automated monitoring stations.
Thank you very much. Is that where, and I'll ask the council this now, if you want to come back on anything you've just heard by all means, but the council provided some sort of monitoring data at points at various water bodies, and I think there's a specific reference to the Brookside sampling point. Is that in respect of Horbeach Lane sewage treatment works? Sorry, wastewater treatment works, I do beg. Would it come via Horbeach? Sorry, Horbeach Lane. Would it come via? Sorry, Mr. I might have asked the wrong the wrong person.
The Brooks on the Waldron's Gill, the Brook sampling point and monitoring station, which is owned by Environment Agency, that is upstream of the Wines Cross wastewater treatment works dispose. So unless you have pollutions which is able to be like a fish and swim upstream, then no, that sampling point is
it doesn't take any data from what comes via Horbeach Lane.
Sorry?
Does it capture any data from either Horbeach Lane or Vines Cross?
Because the Horbeach Lane, if you think about this, that is like you are in Oxford and we are in London through the Thames. Hopefully it goes through Oxford. So basically, no, it's unable to capture any factual or any physical data of what's happening past on the outlets quality of water from the Wines Cross wastewater treatment works. And the beaches waste and pumping station. There's no chance of Beaches Farm have any effect on that point of sampling too.
Okay, that's useful to know. Thank you very much. So in terms of that which the council provided, I probably can't draw any inferences or conclusions from it.
Not from that specific reference. We still talk to the other pieces of evidence, such like the management plan for the wastewater treatment works and what that identifies as pollution issues. But yeah, that specific reference to Brookside Bridge and the data that we have about that, I don't have any information to counter or say anything contrary to that. Like I say, in the information we provided to you, whilst we give you the data around that, we do also describe it as north of Vines Cross, and that does appear to be upstream.
Okay, thank you. Looking at the other sets of data now, I don't want to go into ecology in detail just yet. Excuse me, but in terms of the data, for example, shown for the Cuckmere to Alfriston to Arlington water sampling points, just so that I can understand what they mean. And I've just chosen two examples. Is high invertebrates good, and is high for copper good or bad? Because it would seem to me potentially that being high for invertebrates might be good, but I'm not sure necessarily about being high for copper. I just want to be able to interpret those and understand those monitoring points a little more.
Sorry, can I just say you cannot attribute, if I, what is the, can I stand up and see what you're seeing on the screen, or is that
No,
not?
that's
legal?
not-
it's not on the screen.
Oh.
Sorry, I've made notes of it when I was
What is
looking
the
when I
chemical-
was looking through. The council provided a number of water sampling points in its further information that it provided when I had the questions about
Yeah.
the triple SIs.
Okay,
So what the council did is it's provided, I think there's about 5 or 6 monitoring points. I think they're generally on the Waldron Gill or the Cookmere
and then,
River. And I just had some
can you repeat
questions
the
on
name
the-
of chemicals, or chemical composition of the, what are they?
Well,
Copper?
the first word that you see, this is where my mind was slightly unclear because for example, one of the categories is invertebrates, so obviously insects.
Yeah.
But then another category I looked at was copper.
No, the only thing I would say you
Yeah.
want to focus is a BOD, is a biological oxygen demanding bacteria, which is basically bacteria which require a large quantity of oxygen to be, and phosphorite, if I remember correctly, but ammonia, sorry. Phosphorite is from the farm use. Ammonia is also from the farm use, but also high level of ammonia could be attributed to wastewater treatment works not working effectively. But I'm drawing that from designing wastewater treatment works for sites which are not on public sewer. So ammonia and BOD, which is, I believe is biological oxygen demanding bacteria, something like that.
So my understanding is good in relation to things like invertebrates, fish, etc., indicates presence of the species, and that's ecologically sound, beneficial, etc. Under chemicals, you divide them up into priority hazardous substances, priority substances, etc., and you either get a good, which means it's below problematic levels, or you get a fail, which means there are unacceptable levels of those chemicals.
And I would also add, so although I can't be certain, that there are footnotes and explanations provided during that data that refer to invertebrates, and there was one reference, although it's lost to me now, where it stated that there are risks from invasive aquatic invertebrates. So I'm wondering if the scoring system is to do with whether or not there are those invasive species, and therefore it's stated as being somewhere on that spectrum, such that if there were invasive species, that they would have a knock-on effect on other more native species in the area. So I don't know how pertinent it is, but to the consideration around the point being made by us in relation to pollution, that measure invertebrates, but that's what I seem to be inferring from the information on there.
So, Mr. Wojciak, you mentioned BODs, ammonia, possibly phosphorus. And wouldn't result
No,
from sewage.
no, in the high concentration. So the definite sure is you have, I don't know if they test water for it, is E. coli bacteria that would indicate raw sewage spills. The biggest problem is the aerobic bacteria, because what's happened is they have a high consumption of oxygen to multiply, which in turn kills any aquatic life, because any aquatic life needs water. So I'm drawing back from when I was at university, when you have to go and take a samples from Thames in Kingston, for instance, and compare that at different times to see if we can grow any polycysa. There is a high chance that EA would request us to put something downstream of the wastewater treatment works, i.e. reed beds, further planting, further attenuation and release to provide additional treatment to decrease the value of those chemicals leaving the site.
But that's in a private.
But that's on completely different, not relating to this case at all, site. There's nothing that site can do to improve foul water outlet, because by the same definition, if you would try to apply to Environment Agency for a permit to release foul water via treatment into the stream, on the first question which we would be asked, we completely fail, because the question says number of dwellings multiplied by 30 meters, measure from the site boundary, is there a public sewage system available? If you click yes, the application is automatically thrown out saying speak to sewage undertakers. You are not allowed to have any consultation any further on that point. So Environment Agency recognized that you having your own treatment plants on site, despite of being small or big, is always a higher risk of pollution than to connecting into a statutory undertaker such as Southern Water, Thames Water, to connect your foul water drainage into.
Okay, thank you very much. I've got a question for the council, and then I'll come back to the appellant again.
So my understanding is good in relation to things like invertebrates, fish, etc., indicates presence of the species, and that's ecologically sound, beneficial, etc. Under chemicals, you divide them up into priority hazardous substances, priority substances, etc., and you either get a good
anywhere in terms of a proportional uplift at a certain location that the council can assert
acceptable levels of those.
as an effect that the appeal scheme would have.
And I would also add, so although I can't be certain that...
not directly, sir, no, we don't quantify that. The evidence that we put...
provided during that data that refer to invertebrates, and there was Southern Water now themselves that talks to those environmental impacts, and so our questioning to Southern Water about those impacts hasn't resulted in satisfactory answers to us, which is why we are where we are today. So no, we don't have specific data around the amount of foul from this site and the contribution that would make to pollution from the overflows that occur, other than that the overflows do occur, and as laymen in that respect, we are saying that there must be an issue around that, or one that we have not got a satisfactory answer to anyway. And just going back to the question that you asked before, I just didn't follow the answer given completely, but I completely understand the point about the agricultural impact on watercourses. However, the information that we provided you, sir, in advance of the hearing, particularly that from our, in response to your 16th of December letter, and the information that we also provided from DEFRA's website, does distinguish between the phosphates being discovered in the watercourses, and the distinction it makes is those phosphates and whether or not they've come from rural agricultural practices, and then differently to that, whether or not they've come from sewage discharge. They're just in table form in the information that was provided in our response. They're the tables from the DEFRA website themselves. So I just didn't follow that there weren't those impacts when they've been identified by DEFRA themselves.
Yeah, come back on this. Yeah, just one thing that I can see what you're saying. My colleague has shown that to me, and yes, but that's sewage discharge, which could be attributed to every single wastewater treatment plant, whether it's a wastewater treatment plant owned by Southern Water, or whether it's individual wastewater treatment plant by basically residents who are not connected. Anything upstream on rural area who is not connected. More over than that, actually, there's quite large quantity of houses which are actually on septic tanks, which don't provide any form of treatment. And even now, they are completely prohibited people are not in sort of desperate need for some reason to upsize them. So quite often you can notice when we are asked, when someone buys a property, they notice on a septic tank, which is prohibited. So it's not, I would say, I wouldn't personally point finger only on Southern Water, saying if there is something as a chemical composition in the water which shouldn't be there, although they are more concentrated, larger scale of it. But if you look probably on the individual location upstream of Wines Cross, there is data there which already indicates that all of those chemical compositions are present, and it's from simple, again, people using and living in that area.
And I don't dispute that, sir, but I would just add that we'd have then looked at the information kind of mutually exclusive to each other. If there's that information from DEFRA about the different water bodies and the environmental state of those water bodies, well, we've just then cross-referring that back to something like the Wastewater and Treatment Works Management Plan, where Southern Water themselves say that there are environmental impacts from the issues of the performance of that wastewater treatment work, including actually a direct reference to phosphate from water discharges.
So if I had to quantify what might be the effects, or try and deduce that from the council's evidence and the council's case, can I make any conclusion whatsoever in terms of pollution?
Well, I think the starting point, I just want to say something about the regulatory regime in response to what was said. You start with Section 94 of the Water Industry Act, which imposes the duty on undertakers like Southern Water to effectually drain their area. That duty in Section 94(1)(b) is extended by Regulation 4.4 of the Urban Wastewater Treatment Regulations 1994. So the duty to effectually drain includes complying with the 1994 regulations, and they require plant, which includes pumping stations and wastewater treatment works, to be constructed, operated and maintained to ensure sufficient performance under all normal local climatic conditions. That's the statutory backdrop to the Environment Agency then using its powers under the environmental permitting regime to set permit conditions that ensure that that plant operates, including discharging into water bodies, in compliance with the Urban Wastewater Treatment Directive as implemented through the regs. And so what you'll find in an environmental permit is usually a requirement for a pass-forward flow of a particular number of litres per second. There may be storm tanks that are associated with the infrastructure as well, and then a permit condition which only permits the operation of a storm overflow if A, you're passing forward the required flow, and B, you've used any offline storage that is required, and the condition will usually say you're only allowed to operate your storm overflow in conditions of high rainfall and snow melt. So effectively it's the exception that's in the wastewater frame, the Urban Wastewater Treatment Directive of exceptionality. Under normal operating conditions, the foul waste is meant to be contained within the system, treated and then discharged as treated sewage effluent into a water body. And essentially the concern here is that the Hall Beach pumping station and the Vines Cross wastewater treatment works are spilling too frequently. Southern Water aren't disputing that. What they're saying is the cause is infiltration. It's not rainfall and snow melt, it's infiltration into their system. Now that's part of the well-publicised issue around Environment Agency and Ofwat investigations into sewerage undertakers. The basic argument is they're in breach of their Section 94 duty as extended because they haven't ensured that they have sufficient capacity to treat everything in their system, and they are too readily using storm overflows, not in exceptional conditions, but because they haven't tackled problems like infiltration. And so the simple point really is that when a storm overflow is operating other than within its permitted conditions, that is contrary to that regulatory regime. It is by definition harmful to the public interest and poses the risk of pollution to human health and the environment. So one doesn't need to get to the stage of then having to quantify it. That's almost to invert what Condition 13 is doing. Condition 13 is there to ensure demonstration of sufficient capacity. It doesn't require the local authority to say, if there's not sufficient capacity, here is the evidence of the harm that would be caused. The very rationale for imposing a capacity-related condition is the guardrail to ensure that capacity exists before occupation occurs, and that's consistent with the way in which the regulatory regime operates. You have conditions only authorising the operation of the sewage overflow, the storm overflow, in those exceptional conditions.
So is Pool Beach Lane treatment, sorry, pumping station, are you suggesting it has breached its permit conditions?
That effectively is the it would need obviously an investigation into each spillage, but the spillage figures that are produced in the letters and the evidence suggest that it's spilled well in excess of the number of spills that, for example, the government's storm overflow reduction plan seeks to reduce to 10 spills a year, and I think 29 in the previous year we see in the papers. So it's operating at a high frequency, well above the target levels for storm overflows that the government is suggesting. Obviously, it would need each individual spillage would need to be investigated by the Environment Agency, and if there's a breach, prosecuted. But the essential point is that there are a high level of spills. Southern Water's most recent letter accepts there are discharges from those pieces of infrastructure, and what it's telling you is the cause is rain getting into the sewer network. Now, what I'm saying is that the permit conditions will typically allow the use of a storm overflow in those exceptional conditions, rainfall and snowmelt. What they don't allow is you to use a storm overflow where your system is overloaded by infiltration. Essentially, that's an admission that you're in breach of your Section 94(1)(b) duty to provide adequate capacity. And this isn't the planning system usurping the regulatory system. It's accepting there is a regulatory system there that can require a particular outcome, i.e. sufficient capacity, and the condition just stops the development coming forward until that exists. There's no answer today. Well, you can issue some fines if they're breaching their permit. If the permit breaches are attributable to a lack of capacity and infiltration, that doesn't cure the problem. And what Condition 13 is doing is holding back development until the actual root problem is addressed.
What would be the measure of that, just out of interest?
The measure of addressing the root problem, it would be presumably something from Southern Water demonstrating headroom in a coherent manner. And as I say, that's not what we've got. What they say is the answer to the problem they've accepted. The answer to the problem of the use of storm overflows at the wastewater treatment works and the pumping station, they say, is to prevent rainwater getting into our sewer network. But that doesn't explain why there is capacity. They say the frequency of storm overflows as it is excessive. I think that's a typo in their letter. Is basically the cause is surface water added to wastewater that causes the spills, not wastewater alone. They've not explained how adding wastewater to a system which is frequently spilling, we would say in breach of permit, can do anything other than make the problem worse. And their response about their change of approach, this is the final substantive paragraph of their most recent letter, where they seek to explain the change between the 14th of February 2022, and the most recent responses, they say the change in our approach, this is a change in our approach to desktop assessments for wastewater inquiries. It means that hydraulic analysis is now required under certain conditions. Specifically, this analysis is necessary if the proposed development exceeds 50 properties or has an equivalent commercial demand, also required if the development is in a known problem area, such as where a preliminary desktop assessment identifies DG5 flood register or SIRF sewage incident report form incidents within 100 metres of the site. There have been fewer than 5 incidents in the last 10 years, so hydraulic analysis is not needed. What their change of approach then is basically their own internal processes. They've set a threshold of 50 dwellings, and they've set a threshold of a number of incidents within 100 metres of the site, and on that new basis they don't need to carry out a hydraulic assessment. So they've screened it out. They're not presenting to you a hydraulic assessment that says we've calculated the headroom and here's what it is. They're saying because we've changed the screening threshold for objecting to new development and you're under it, we no longer object.
Okay, thank you very much, Mr. Walls. Ms Davies, does the appellant want to come back on anything further before I move on?
Oh, sorry, two things. From the letter which was sent on the 18th of March to Wealden District Council, Southern Water does read that they did do hydraulic analysis on that site, probably following the initial consultation with Wealden when Wealden asked for clarification. But in that letter of 18th of March, it does clearly reads that they did do a hydraulic modeling of that section of the site and compare that with the real value of the site. Oh yeah, and we
Just on that, could you point to the particular paragraph that says that?
is what did you say? It's a third from the bottom. It starts after the italic font.
So yeah, I guess reading one, two, five from the bottom on the second
Yeah.
page, it explains the tool that Southern Water use, namely a hydraulic model. It says that this is a representation of the sewer system built within a computer program. It's built and then tested against real data, strategically placed, which is this point in background truthing. And then it goes on in the third from the bottom paragraph to say, as previously mentioned, Southern Water carried out a desktop assessment as detailed above.
That's right, and then it's the second sentence of that paragraph. It won't cause a problem because the problem isn't caused by wastewater alone. It's that is the logical fallacy in the reasoning.
Well, I think the simple point is that they're saying it's not a problem that arises from this site, it's surface water that causes the problem, as we've,
And I did actually ask both Southern Water and Environment Agency if they have any data which they could share with us on spills. And Environment Agency said nothing was to be given to me as in the public domain. And I specifically asked for that NCI, which is non-compliance notice for regulatory permit. And they just didn't come back to me with anything. Well, I don't know how to take this.
Okay.
I mean, just on that, you've heard my point about why we were having to deal with their environmental information team. If there's evidence of spills, the Environment Agency will be investigating that. That will be producing a prosecution if they appear in public inquiry and reveal their hand.
Okay, thank you both very much. Just a couple more questions on pollution now. I think this might have been clarified earlier. The role of the what's the role of the Rivers Trust, and how is their data captured on in terms of number of hours for the spills? Because I think you've included data of 2021 and 2022. I just wondered how that's captured.
So the Rivers Trust themselves are an organisation. I'm not sure if they've got charitable status, but nonetheless they campaign around improving water quality and the use of water as a natural resource up and down the country. They publicise something called a sewage map, and the data that feeds that, my understanding, comes from the utility company's own public data, which actually is, I can't remember the figure off the top of my head, but it's somewhere in the region of 90%. You know, they've got monitoring stations up and down the country at all their water courses, and so the monitoring is quite effective, and they use that public data to feed it into their online map and any reports that they do. And so we use it, or had been using it, because it was a good source of information from a user point of view. Southern Water's own website can be quite difficult to navigate at times, although to be fair to them, they've made a lot of information more publicly available and more easily publicly available as well. But I don't believe that well, I don't consider that we would mistrust the information presented on there, just because, like I said, it comes from public information. It's a little behind the decision notice letter that we sent in relation to this discharge condition application referred to 2022 figures. There are actually 2023 figures available on those. I don't intend to submit those to you, sir, today. It's just interesting, though, that from what I can see anecdotally, there's double the amount of discharges there were than in the letter that we gave you previously. But yeah, that's what the Rivers Trust data is.
And just to add to that, over the last few years, the Environment Agency has rolled out what they call EDM, or event duration monitoring. So it's now a permit condition for most installations, most storm overflows, other infrastructure that discharges, that they have an EDM monitor, and that measures both the time and the duration of any discharges from a storm overflow. That has to be reported on an annual basis to the Environment Agency. It is public information in the sense that both the statutory undertaker is a public body and has to respond when asked for that information. It's also held by the Environment Agency, which is a public body, and so now routinely the information is published, because it's material that would have to be provided, and bodies like the Rivers Trust take that information that's generated by the EDM monitoring and publish it on their own websites to highlight perceived problems. So it's not monitoring that the Rivers Trust itself has gone and carried out. It's them reporting the data that the statutory undertakers are required to record and pass to the Environment Agency.
Ask the appellant, how much weight can I give to what I've heard in respect of the Rivers Trust data?
So in Southern Water own website, when they analyze the spills data, which is all of the information which is available, from which River Trust takes their sort of data from and publish it in more manageable for non-technical members to understand. They did acknowledge that 2023 was exceptionally high rainfall intensity year. So it's very sort of, they all hold Southern Water holds their hands up and say 2023 was exceptionally high, and hence the high attribute of any emergency spills and release of water from any of their apparatus, based purely in their designation through the compliant of being such a wet summer. And lead local flood authority, i.e. East Sussex or Kent, they also attributed the last year to be exceptionally high when it comes to anything from the groundwater level being really high because of the amount of rain we had in 2023, through to the need for any systems as a drainage system to be robustly designed to be able to cater for such a storms going forward.
Okay, thank you very much.
So perhaps Mr. Best is best placed to comment on weight. So.
Yes, so I think you could attribute moderate weight to those findings. Not significant because obviously they are provided by a third party, but given that they ultimately stem from Southern Water's own data, it would be unfair to characterise it as limited.
Okay.
And just to add, sir, that there's a process that takes place between the undertaker collecting the data and returning it to the agency, that the undertaker itself will effectively triage that raw data and screen out any things that are attributable to the monitor not working properly or other results. So they have been. It's not just the raw numbers that Southern Water passed to the agency and published. They have undertaken an exercise to effectively verify that the accuracy of the data, because there obviously are occasions where the monitor will be damaged or produce a return that's so obviously wrong it might record what in substance is one event as multiple stop-start events, and so there is a process where they look at the raw data before it's passed on.
Okay, thank you.
Obviously, my submission that goes to the weight because there is a sort of verification stage that underlies the numbers.
So, what weight would you say I can give it? Do you agree with Mr. Best?
Well, I think it deserves more than moderate weight because ultimately it's monitoring that is a legal requirement under an environmental permit provided to the environmental regulator, having been analysed and verified by the statutory undertaker before it hands it over. So if you're satisfied that the Rivers Trust is accurately putting on its website those numbers, there's no suggestion it isn't, then it deserves significant weight because it is effectively an official return. The monitors themselves have to comply with universal technical standards as to the accuracy of the devices, as you would expect. And the whole point of those monitors is to measure regulatory compliance, so I would say significant weight.
Okay, thank you. One more question on pollution. The appellant, in paragraph 3.12 of your appeal statement, you refer to a condition that is impossible to discharge. Do you mean the condition is? Are you inferring that this condition would actually be impossible to discharge with the council's stance? Is there not other technical solutions or mitigations to deal with foul drainage, such as I don't know, maybe a package treatment works or a holding chamber? I say this with little qualification, but I just would like to understand that there are not other solutions.
Packet treatment plant, I already explained when we touched base about trying to install one on site. We would not comply with environmental agency rules and regulations, so that's immediately ruled out. And that's the only way, other than tanking the sewage away from the site, which are physically possible. Either you have to treat it on site, send it to a sewage system, which is untreated then, or tanked it off site. I think that's the only three physically possible solutions to provide on any form of residential development. Yeah, so packet treatment works, connection into the sewage system, which is public, i.e. Southern Water, or option number 3 would be to tank it, which I think it's not really an option on any residential use of a dwelling.
Do you disagree with what the appellants said there in terms of that they're potentially facing a pretty impossible position?
Well, I do disagree. It's looking at it from the wrong angle. The requirement is to demonstrate capacity in the network. It's not for the appellant to do something to deliver that capacity. That the whole logic of Barrett is this type of condition is delaying development until either infrastructure improvements are delivered via Ofwat and the price review mechanism, or something else is done in the network to create the capacity. So take the example of Cambridge North Station. We saw their capacity, in that case for sustainable water supply, was delivered not because the appellant was offering or doing anything, but because of other initiatives which created the headroom. Here we're being told that the principal issue is infiltration, so it's not infrastructure construction that is required. There are targeted measures that could be taken to deal with localised infiltration issues. There's no evidence that that's been investigated or that it's difficult or even impossible. So it's wrong to approach condition 13 on the basis that the only things that can deliver capacity are those that are within the appellant's control.
That might have been an answer to the way I phrased my my question, but okay, if I can ask the appellant if you want to.
So, sorry, can I just come back very quickly? It would be completely back to front to ask the appellant to convince Southern Water to resolve a problem that it doesn't believe it has. They're simply not going to do it. It speaks to the reasonableness of the condition.
Plus, you've got my points from earlier, sir, about what condition 813 actually requires. And as I mentioned previously, a point of major distinction with Barrett in that there were very clear, concrete solutions in that case which required resolution prior to the development commencing, and that is far from the case here.
Okay, thank you both very much. I think that's my questions on pollution now. At this point, Dr. Hall, I had a brief look through your submission. It was primarily pollution based. Have I captured the points you wish to raise, or is there any outstanding matters?
Yes, I'm grateful for the opportunity to present my two submissions to the appeal in person. The first is actually an endorsement of Wealden's refusal in this application, and the second is a record of my attempt to obtain real data as opposed to opinion from Southern Water. And first I'd like to just have a quick reality check, which is that we are talking about discharge into a ditch, which in 2023 occurred on 35 occasions for a total of 219 hours. This is a discharge from a pumping station that was actually built 40 years ago to collect the sewage from about 40 dwellings. It now copes, I thought, with 160, but I've heard this morning from the appellant that it's actually 186. So this is now dealing with over 5 times its original design capacity. Again, on the figures from this morning, the 224 houses that drain into the Horbeach Lane pumping station will now contribute something of the order, and this is the back of a piece of paper calculation, 300 cubic meters a day of sewage. The pumping station is believed to have a holding capacity of only 3,000 gallons, which is just a reminder of the fact that this was built 40 years ago when gallons were the unit of measurement. That converts, roughly speaking, in modern money into 13 cubic meters. So 13 cubic meters of holding capacity are going to deal with 300 cubic meters of sewage per 24 hours. I have to say, these are guesstimates. The fact is, none of us actually have any figures. We're operating in a data desert. We just have Southern's undertakings about things. We actually have no figures at all to deal with. Southern Water's position is that sewage discharges are due to surface water ingress, and not the sewage loading of the system. They actually have no plans to either reduce the water ingress or increase the holding capacity. Their proposed strategy is simply to add the additional sewage load and see what happens. Wealdon District Council has the general duty of care to its served population in terms of public health and protecting them from surface water pollution and the environment likewise. And in my opinion, its planning department can only conclude that the intended inaction by Southern represents an increased risk of surface water pollution. This is into the adjoining ditch from the Horbeach Lane pumping station, nothing to do with Vines Cross at this point, and that therefore condition 13 of the appeal judgment has not been satisfied. And I just append a photograph of the offending outflow CSO discharge for those who actually don't fancy wandering across a muddy field this afternoon to inspect it for themselves. So that's my support and endorsement of Wealdon's position. And the second thing I sent in is a result of my attempts to get any information at all out of Southern relating to their position. The appellant this morning keeps referring to evidence. And this is precisely what we haven't got. We're operating in the absence of evidence, and a statement by Southern Water is not evidence. It's an opinion, it's a statement. And basically, this whole issue is one of trust and credibility. Can we believe what is said? Can we investigate what is said? Can we believe and understand and accept what is said? Southern's position is that connecting an additional 38 dwellings will not increase the risk of raw sewage going into the adjacent ditch, as the increased flow would be, in their words, quotes, minimal. This opinion is based on, and then quotes again, a desktop assessment and a capacity check. We've heard so much about this. No details at all are provided of that calculation. It's a statement. They did it. It's okay. Believe us. Despite their business being a public utility, Southern Water as a private company is apparently not covered by the provisions of the Freedom of Information Act, but they do comply with the Environmental Information Regulations 2004. And as an additional 38 houses represents, and again, we don't know exactly, but 20 to 25% increase in the sewage loading of this overloaded system, it really, using the term minimal, in my opinion, requires some justification. So in November 2024, I requested, and I quote, the details of this desktop assessment, including the data used, its interpretation, and the confidence limits applied to the conclusions. This request was duly refused on the grounds that, and again I quote, this information would be classed as internal communications and the disclosure would adversely affect the internal decision-making process within Southern Water. There is an opportunity to appeal against this on an internal review of this decision. So in December, I requested the available internal review, as my request actually was nothing to do with internal communications. It was about the data. I wanted to know about the data that they'd analysed, the conclusions they'd come to. I've had a reply indicating that that review is going to be processed. I'm promised an outcome to that by the statutory deadline of the 30th of January 2025, in other words, 2 days' time. I've just reread the reply I had from the head of legal at Southern, and actually it doesn't say I'm promised it, it says that he hopes to be able to provide it within the statutory deadline of 40 working days. So we wait and see. And I just wanted to say separately that whatever the outcome of this planning appeal, I intend to refer the details to the government's independent commission on the water regulatory system, which is currently sitting, as a clear example of the impossibility, the difficulty facing local planning authorities in ensuring that new housing is provided with the necessary foul water infrastructure before occupation. Thank you.
Okay, thank you very much, Dr. Hall. I've not got any further questions upon what you've said. It's you've covered the points set out in your submission. Did the council want to respond on anything they heard there?
I don't think I'm entitled to. It's on my side, as it were. So.
Okay, and the appellant?
So being an engineer, I can, for many sites when we design system, we carry out hydraulic analysis. It's a file which we always attach to any drainage strategy. If you've seen drainage strategy for detail of condition related to surface water, it's probably 30 to 40 pages of outlet printing, which I would say that anyone who is non-technically minded will just look and really not understand what you see. And I'm not saying that as a engineer, I'm saying that the outlet is, unless you specifically know what you're looking for and how it's all adding up, and you have a whole model of the system, I'm not defending Southern Water of saying, take my word for it. I'm just trying to see that for every site we produce, we have to do it, we're getting paid for it by our clients. If I'm Southern Water and I'm on the budget as an engineer who works for them, let's say, and for every site I do capacity check when we add extra 20 units, 30 units, 50 units at specific location, you can plug this into the model and get the outlet. But if you literally are not trained to understand the output, it's a mathematical model. It's not something fancy, three-dimensional analysis which would show you specifically. It's a mathematical model. If you don't really see it, I'm fairly sure that, if I'm honest, I don't want to put an example because I don't have it right now, but in the past when we were asked quote for detailed designs for site, we noticed that there were models produced by others who literally were flooding on the scenario 1 in 100 years, which they were accepted because I'm guessing someone quickly checked it and didn't understand what they're looking for. So it's, I think Southern Water are trying probably only to limit amount of resources they have. If they say that they have carried out the capacity check, I would say it's worth looking into it as you can pursue on your own to request that model. I'll be more than happy to even explain that to you in more details, completely professionally, without any conflict of interest, saying what I see as numbers, because most of those models will literally say okay, not okay, and red is bad for most people when it says flat. But you don't really, sometimes you see sites which even use different synthesized methodology, and I've seen on LinkedIn, Chartered Engineer recently boast about how using different methodology creates a different outfall, and look, on the standard approach it was okay, but once you use the latest method, it actually flooded. But if you look at the site, for instance, that specific, it did flood, but the flooding was a bucket of water, 0.04 of a cubic meter. So I know it's completely irrelevant. And when it comes to, like, I haven't seen the photos which you say about that outlet being in a polluted state, but when we were back in 2022, there was no conversation or even at the time on anything raised about the lack of capacity. The only problem was the EMO. We were actually asked to undertake a multiple condition surveys of that surrounding water courses that our lead local flood authority asked us to provide them. I don't know if you had a chance. They are on the public domain. They are on Wealden District. They were used. Wealden were happy with it. East Sussex were happy with it. And I've been on that site twice. And on those occasions, which I've been, plus my colleague, who is also chartered engineer, Hugh, attend once, because he lives in Helsham. So he has a vested interest of this site working well, I would say, more than most of us. On the photos which we have, you can see that there are literally whole survey of the stream, which we captured to prove to lead local flood authority that the stream is capable of accepting additional, it was to do with surface water, but still, there was no real signs of any hygienic products, any excessive, I would say, pollution, which you could sort of witness and say, oh my God, that's disgusting. No, the sewer pipe is still there. The outfall is exactly the same location. And we surveyed that in the time when the outfall is still operational as it is today, basically. So when we were there on multiple site visits, you can check that on the planning portal. It's a condition survey reports, which we produce. then we captured, as we walked down the stream, we had to sort of dig up and down and take photos. We did capture, I would say, stream quite accurately, and we couldn't, at the time of my 2 visits plus my colleague Fer, we didn't find something which would say, oh my God, you know, it's really not what it's supposed to be. But that was at the time, which is 2022, and I wasn't completely made aware that, let's say, that Wilden will ever refuse that application on any grounds of pollution or no capacity at the time. So that was completely, I would say, open to see what I see rather than trying to capture a site in its glory. That makes sense.
Okay, thank you. One final point yet?
I mean, basically, you see pollution when it happens. If you're not there when it's happening, you don't see it. I don't see that that proves anything at all.
Given that, yeah, any viewing is a snapshot in time, but no, I appreciate that. You, sir, sorry, you had your hand up. Is it in terms of pollution? Right, okay. If you would like to come up for a couple of minutes.
Ready? Good afternoon. Welcome. As I said earlier, I'm a Wealden District Councillor for Heathfield North, and I believe that is the source of the Wealden Gill and the Cookmere. I'm here today to fully support my officers on the Condition 13. I sit on Planning Committee North and I sub on Planning Committee South. I was not on the Planning Committee when the original application was discussed and refused, but I did attend the previous appeal when the inspector handed down the permission for this site. There's a few questions from this morning and what I've just heard. The appellant is going to introduce a second pumping station into the site. That's correct. So that introduces a second vulnerability into the site. Earlier we've been talking about this, I'm jumping around here. We heard evidence that the Rivers Trust data is there, and I've got that data here. If we talk about the Horbeach Lane pumping station, the total 3 years for 21, 22, 23 is 107 storm overflow spills, totaling 867 hours. 2014 is not here. If we go on to the Vines Cross water treatment works, indeed 23 was the highest. But over the 3 years that I mentioned earlier, there were 182 storm overflow spills, totaling 2,542 hours, which is precisely the reason when I sit on a planning committee, I feel comfortable when we introduce Condition 13, that if I approve that application, I'm protecting current, future, and the biodiversity with that permission that I'm granting. The decision today is really important. It affects what I do as on a planning committee going forward, and what I've done in the past. Data, interesting. In 2010, a report was produced on dwelling overheads. Today, I've not heard one piece of data that tells me what the overhead capacity of Vines Cross treatment work is. In 2010, I can tell you what it was. It's 1,190 dwellings. But today, no one has actually given me any indication what that overhead is. That's 15 years ago. So I think in 2025, it's not without question that we should be able to provide that data, whether it be you, or whether it be Wealden, or whether it be Southern Water. It is an algorithm, or it is whatever. I had the privilege of visiting a sewage works for 2 or 3 hours, and we questioned them quite rigorously. And the one answer that I asked was, what was your maximum flow into that treatment works? And it was Hailsham North, and they knew exactly what that was. The next question was, what happens if it overflows in the treatment works? Oh, there's a stainless steel trough and it flows straight onto the Pevensey levels. So does it concern me that we're here discussing condition 13? Yes, it does, because it gives me comfort that when I make a planning decision, that my council and my officers are willing to actually stand up without the absence of data. No one has been able to tell me what the overhead capacity of Vines Cross treatment works is today, when they could in 2010. In fact, they gave every overhead capacity for every treatment works within the Wealdon area. So there we go. I'm not going to say too much more. And in fact, I'm not going to mention Barrett or Wales because I live in Wealdon. And I think that's relevant. We're talking about Wealdon, which has got a very high target from the government for dwellings, new dwellings, one of the highest in the country. We've currently been told we're going to get more than we have now. So I think it's quite right and proper. We should know exactly what we will be delivering to our residents and what safeguards that we have going forward. And I've not heard today anything that contradicts why we should not put condition 13 on our planning applications. Indeed, at committees, I've tried to strengthen that by including the associated water courses where the pollution goes to. We talk about...
Sorry, what relevance is this to the...
I don't know really, but there you go. Anyway, I'm going to get onto the relevance. I have investigated Southern Water's planning applications into Vines Cross. Since 2006, there's been 2 planning applications, and one of those is relevant. And it was the Planning Commission in 2012 to put in 2 kiosks, and one of those kiosks was to introduce ferric into the treatment works to control phosphorus. And that has been brought up today. So they did do it, but I can't see anywhere where that has increased the capacity. Also, ferric is a controlled substance, and the Environment Agency, I believe, give out licenses and restrict its use. So what good that's been, I do not know. Yes, I'm getting passionate, and yes, it may not be relevant, but it's relevant to me because I have to make decisions on what I feel and how the council adds conditions to planning applications. And I think I'm going to stop there now because I'm getting too worked up. And it is something we need to worry about, the environment, future and current residents. Thank you.
Thank you, Councillor Gadd. Right. If now got a question first of all in respect of the Pevensey levels, which was just referred to a short time ago. Okay. Yes. Yeah.
Just briefly, because a lot has already been covered. I just want to highlight the fact that Vines Cross pumping station has water treatment works. In 22 had 42 spills of 23 days, and in 2023 had 86 spills of 58 days. Now, between 22 and 23, the Rosemead development, which is opposite this site, was completed and everybody had moved in. So you can see how that had an immediate effect on the amount of spills there was at Vines Cross. At the moment, it has been discharging since 9:30 this morning, And in the last 7 days, up until first thing this morning when I came out, up until 9 o'clock this morning, it had discharged 63 hours, so just over 2.5 days. And that is just because we've had a little bit of rain. It did stop briefly, and then of course we've had rain this morning, and yet again it's now discharging. Last year I came past the site, and there was a tanker parked in the lay-by, so I couldn't see any connection to the pumping station, so I actually stopped and asked the tanker driver why he was sitting there, and he said he had to sit there until it got to near capacity, and then he had to empty it. And then he said, "Don't tell Southern Water I've told you that." So that's just an insight, because I actually live in that road, so I'm aware of the amount of tankers that they keep putting there to try and prevent spills going into the Cookmere.
Okay, thank you very much, Councillor Lane. Sorry, in respect of the Pevensey Levels SAC and Ramsar site, can I just confirm that the council and the appellant are in agreement that there would be no significant effects? So I don't have any duties under the habitat regulations as far as you're both concerned. Now, if I ask this to the council first and give a little bit of background. So the council provided me with the Arlington, Milton Gate and Seaford to Beachy Head SSSI citations. I think Natural England for completeness, because it was referred to the Pevensey Levels as well, and its consultation response. The council also provided me with the what it understands to be the conservation status of the 3 SSSIs, which I informed are fed via either the Waldron Gill and or the Cookmere River. You'll have seen the consultation response from Natural England, the latest one. The reason why I did this is again legislative duties under Section 28 of the Wildlife and Countryside Act. I wanted to ask the council. I'm going to ask you about each SSSI individually, all 3 of them. But in light of what's said there and the evidence you've provided me with, can you explain what the council feels would be the nature and significance or magnitude of the effect of the appeal scheme upon the ecology of, if we start with Arlington? I noted that from what I can see, most of it isn't hydrologically linked to the Cookmere River from what I was able to ascertain, but some of the SSSI does still encompass the river from what I could see.
Yes, sir, that's right. I think it's a common theme between all of the information relating to all of the SSSIs that we sent you, that what's been identified as issues in relation to them are matters relating to discharges from foul drainage. But I think this is very similar to the question that you asked us earlier in relation to pollution issues generally, and whether or not they can be quantified. And so I can't do that for you today. You've heard representations about the number of additional developments that have been plugged into the sewer network. The council haven't laboured on that. What we have presented to you, though, are information from different sources, now including these SSSI reviews for the 3 different that are associated with the relevant watercourses. And again, just like the management plan from Southern Water themselves, which focuses on Waldron Gill, these identify issues in relation to drainage. The council has not been satisfied when it comes to the discharge of the relevant condition that this development won't contribute to that. In the crux of the argument for you today.
but what's the effect of the development? I suppose is my question. I've got to. I've referred to the Wildlife and Countryside Act. There's paragraphs of the framework in respect of triple SIs and biodiversity in general. Can you point to any evidence in terms of any, say, qualifying feature, habitat of Arlington or the other two triple SIs where you could form a view that there would be a perceptible harmful effect from the appeal proposal, or any form of effect, or is it simply that there might be additions depending on what I find into the catchment, but in terms of a measurable or an effect of any ecological significance, there is none.
No, not that I can direct you to specifically. In our response to you from your questions on the from your questions from your December 16th correspondence, we do refer to the triple SIs and the information that we've been able to ascertain from that. We mention it in general terms. It's as I've just set out to you, that they identify that discharges are causing an issue, but that hasn't then been expanded to say what specific impact that is having on any particular part of the special interest of those triple SIs. There's a general comment that we've made there.
Just to add, the most recent Natural England email that's been added to the evidence makes clear that water quality issues are listed as a pressure for those SSSIs. But I think we're really in a ships in the night scenario. Natural England isn't asking itself or answering the question, if there are sewage discharges, what would be the effect of it? They're taking as their starting point that there is capacity, and therefore they won't occur. And so that's why they're saying there is no pathway between the proposed development and the designated sites. They're working on an assumption that there's capacity and the infrastructure will perform within the limits of its environmental permit. So in my submission, Natural England's response shouldn't be read as saying there is no harmful consequence in ecological terms of sewage discharges in excess of capacity. It's saying if the requirements of condition 13 are met, that will protect the environment.
Okay, and that would be a principle across all of the triple SIs.
It would say yes.
Can I come to the appellant on that matter?
Well, yes, the council's fortunate in that it benefits from an in-house ecologist whom they could have chosen to consult, but there was no consultee objection from their in-house ecologist. There's no ecological witness here today to demonstrate any harm to you, and Natural England's position is that there will be no harm. And I think what Mr. Malls says is wrong, frankly. And the reason it's wrong, sir, is because any normal person and any reasonable person reading the correspondence from Southern Water will find exactly what Southern Water have said, that there isn't a capacity issue. And so I'd invite you to have the same interpretation as Natural England, which is a perfectly normal interpretation, and find that there is capacity.
And so just to add, in respect of that later consultation response from Ms. Sophie Moore, plainly that invites you to only consider there to be an impact on a triple SI where there is not just an impact pathway but a clear impact pathway. And with the greatest respect to the council, I think their case really is there are potentially sewage overflows from CSOs. That is not a clear impact pathway from this proposed development. And Ms Moore also goes on to say that the impact risk zones with which the council takes issue in email correspondence have been developed using robust evidence. And she says on that basis they did not identify an impact pathway and therefore they were unconcerned. So it's not only on the advice of Southern Water, I would suggest.
Just on that last point, sir, I don't mean to blow open the impact risk zones and their reliability in any way, shape or form, but we have known scenarios within our own district where developments don't fall within the thresholds of the triple SI impact risk zones, but nonetheless we still undertake consultation with Natural England, and in those instances also carry out appropriate assessment, because as you'll be aware, the triple SI impact risk zones don't just serve to identify likely impacts on triple SIs, it's also on European protected sites as well. But we have instances where types of development aren't caught by that triple S impact risk zone, but nonetheless we still identify potential impacts on protected sites. I'm specifically referring to Ashdown Forest, which obviously is not what we're discussing today. I'm just making the point that because something hasn't been identified as meeting the threshold within the triple SI impact risk zone does not mean that there are that there's no possible likely effect from the development. And that's the point that we've made in our submissions to you. And I don't believe that Natural England's response to you addresses that in terms of the concerns that we've raised.
Okay, thank you. The Ashdown Forest, though, that's a European designated site, is it not? So it has a different threshold where a decision maker must be certain there is no harm. Whereas that seems to me, I could be wrong. There's two legally qualified people to tell me otherwise in the room, but that's not quite the same test that's needed for a triple SI under the Wildlife and Countryside Act.
You're right. It's the strict precautionary approach in cases like Vadensee that apply where you've got an SPA or an SAC.
But I do mention it, sir, just to reiterate the point, sorry to labour it a little bit, that the threshold that we apply to impacts on the Ashdown Forest is a 7K zone, and it's for any net increase in dwelling. So any one increase in dwelling requires there to be a mitigation put forward. Now we've got agreed mitigation with Natural England on that, so I don't need to go into that specifically. But the point is that there are no developments within that 7K zone that would then be picked up by that triple SI impact risk zone. So to cover that scenario. So if you were looking at a house that was 1 kilometre from the Ashdown Forest or 7 kilometres from the Ashdown Forest, it doesn't trigger a consultation response from them. That's clearly not what we do in practice because we know there to be a known issue. It's just an example of a way in which the triple SI impact risk zones are used, and the caveat that they have on their own website about their use, and that if there are concerns then or things that we need to draw to their attention, that we do that. I appreciate that's exactly what you've done, but like we set out, we don't agree that their response to you has dealt with the issue in the way that we see it.
Okay, thank you, Mr. Batchelor. Does the appellant wish to say anything further in that regard? I've just got a couple more questions on ecology.
So only that if that was the position the council were going to adopt, one might reasonably expect them to evidence that position, and yet there's no one here.
Okay. In respect of rounding off this triple SI, the triple SI issue, which was the main ecological harm that the council advanced, and not on any specific species. I'm mindful that in reflecting upon what I've heard, if I intend to allow the appeal or consent the proposal, but I find that there might be some damage to the triple SI, then I think I'd have to consult Natural England on the proposal. Means I must allow 28 days for any to comment before issuing any decision of mine. If Natural England comes back with something different to what it has said so far, then I do have to, from what I understand, there is then a 21-day notice period to allow the development to be called in by the Secretary of State, but I assume not called in for me to deal with. I might reflect upon this a little bit further when I come to adjournment or closing, because it feels to me like I might need to adjourn the hearing today and just reflect upon what I've heard in case I feel there are any. I then need to go and consult Natural England and give the parties an opportunity to comment. It could well be I decide to allow the appeal without Natural England consultation, or vice versa. So, but it feels to me like I might well keep that option open for now. Obviously, I've also got to consider the proposal having regard to paragraph 17A and 193 of the framework in respect of protecting and enhancing sites of biodiversity value, and in respect of any effects upon triple SIs. Is there anything you want to say other than what you've already said in respect of the policy test? Anything else? No. Right, that's everything in respect of ecology. Yes, sir. Sorry, what's your name? I don't think I've taken your name. Okay, what did you wish to say, Councillor Fairweather?
Right, thank you. I'm the Wealdon District Councillor for Hurst and Sewer and the Pevensey levels. Such I take a particular interest in sewage discharges and the ecological effects, particularly on the levels. I'm also a Wealdon nominee for the Pevensey Cookmere Water Levels Management Board, but if you want any information on that, I suggest you ask Councillor David White, sitting in the corner there. I'm also Wealdon's representative on the South Downs National Parks Authority. I'm on Wealdon's Planning Committee South, but I was not a member of the committee that heard this originally. I hold a BSc in chemistry. In recent years, last 25 or so, I've specialised in biochemistry, but before that, before I trained as a teacher, my career was as an analytical chemist. And part of that, I was in charge of a holding tank that was upstream of the last sewage works upstream of Windsor Castle. So if we got that wrong, Windsor Castle got brown tide. Something that came up earlier, question about where the water runs. Waldron Gill runs down into the Cookmere River. It's one of the tributaries that then goes down past Arlington Reservoir, past the intake to the reservoir. That had to be closed, that intake, in, I think it was 2019, because of a sewage spill on the Cookmere. Then from Arlington Reservoir, the Cookmere goes down through to Alfriston, I wouldn't be surprised if you tried to take a site visit to Alfriston if you couldn't get there today because of flooding. From Alfriston, the Cuckmere then continues into the National Park, Seven Sisters Country Park, the Triple SI, and what is being mooted as one of only 2 national super nature reserves. So this is a very sensitive habitat, particularly the lower Cuckmere there. The fact that it's being considered as one of the only 2 sites in the country for one of these super nature reserves. I'm very aware of the planning condition that Natural England usually ask for on planning applications inside the catchment area, which is for high quality water. Also, another phrase that they use, stable levels, i.e. no floods. Then we had a number of detailed things that people were asking about earlier that they couldn't answer about. One question you asked was about the invertebrates. Now, it depends entirely what invertebrates they are. Now, if these were caddisfly larvae, great indication this water's in fantastic condition. If it's the invertebrate, on the other hand, is a bloodworm, then it's an indication that it's highly polluted, quite possibly by sewage. Also, there was the question about high copper levels. Now, that is unambiguously bad. How the hell that gets into the Cuckmere, I cannot imagine. The business about biological oxygen demand. Yes, bacteria. But that's an indicator of sewage. Then we had the question about the phosphate or the phosphorus. Now, one of the sources here of phosphates, it could be agricultural, it could also be sewage. Every single food contains phosphates in one form or another. Now, agricultural phosphates, very insoluble, not likely to be the cause of the problem. Sewage overflows, on the other hand, that's putting phosphorus straight into the river. You would need a lot more detail about the analytical method of testing to say what the source of these phosphates was. For example, DNA testing, how much of that is coming in DNA? Because DNA contains phosphate after phosphate after phosphate. Right, that could have come from sewage. Again, we've got the question about ammonia. Now, one of the very obvious sources of ammonia in the water is from sewage. I'm not seriously suggesting that you try this experiment, but if, for example, you were to put urine in a chamber pot and leave it in the hot sun, you'd be able to smell the ammonia. Now, if we've got anaerobic bacteria in the water, that's a sign of bad water quality. Now, aerobic bacteria would love it in good quality water, but anaerobic bacteria can only survive in bad quality water. Question came up about where the sewage might be getting into the river. All the sewage plants in Sussex are Southern Waters. Okay, there might be the odd septic tank, but compared with the amount of sewage that's coming out of Southern Waters plants, it's irrelevant. Also, the question about information from the Environmental Agency. They refused to release information. I asked them, their area manager, a question about this at Wildens Overview and Scrutiny Committee in, I think it was July 2024. They point blank refused to release any information about pollution spills. There's a couple of particularly nasty ones, incidents of dead fish and all the rest of it, but we're not getting the information. Nobody is. Councillor Gadd said about adding ferric, otherwise known as iron 3+, to the Vines Cross treatment works to precipitate phosphates. Yes, it will. The reason why it's not commonly added, iron 3+ solution is incredibly acidic. Now, that in itself would be harmful to wildlife. So, iron 3 plus, it would precipitate the inorganic phosphate.
This
but it wouldn't-
seems to be, sorry to stop you there, Councillor Fairweather. This seems to be going talking a bit more about the generals rather than the specific effects of this appeal proposal.
Yeah. If you could just hear me out, I've only got one more point. The phosphate that would be precipitated there would be inorganic phosphate. It would not precipitate the phosphate that's coming from sewage. And this is important. We've got here Councillor Gadd and Councillor Benton from Heathfield. They can testify to the number of overflows of sewage that are going into the upper headwaters there of the Cookmere River. And this will be upstream of the monitoring station that you were discussing, upstream of Vines Cross. Right, thank you.
Okay, thank you very much. I was going to ask if anybody else has any further points to raise in respect of this main issue. I just have one, and I think it's primarily directed at the appellant, and it was triggered by the recent letter by Southern Water. Can you just confirm for me, Southern Water, because they refer to SODS a couple of times. I'll take it that there's no argument put forward by the evidence or the scheme that the proposed SODS would reduce the infiltration of rainwater into the sewer to such a quantity that it effectively mitigates the effects of the quantity of sewage.
Site specifically, we will have completely designated separate foul and surface water sewers. Surface water will be kept completely away from any connection to the Southern Water apparatus. That's 100% how it's been designed. There's no overflow, there is no risk of pollution. And there was like one comment made previously about we introducing another pumping station, hence we introducing another risk of pollutant. That pumping station does not have any permits, or there's no intention to make any permits for overflow, emergency release. And
yeah, no,
the moment, yeah.
It was just in terms of that, whether there was any sort of balancing exercise.
No, there is none, and I think condition 18 prohibits us from, if we ever pollute from our site, we're immediately in the breach of condition 18.
So I think the point, sir, is that there will be no surface water problem arising from this site, and everything else is within the headroom. Yeah.
No, none.
I think just to focus back on condition 13 and what actually needs to be demonstrated. Mr. Best referred to the council not producing evidence from an ecologist. There is no part of condition 13 that places that burden on the council. Properly construed, as I've said, it is a Barratt condition requiring demonstration by the appellant of adequate capacity. As we've set out in our statement of case, paragraph 42, that has not been done, therefore the appeal should be dismissed. Questions of what harm would be caused if the development were to proceed without adequate capacity are matters which really are relevant to a Section 73 application. They don't show whether there is or isn't capacity, they show what the effect of a lack of capacity would be. And this is really a jurisdictional point. There is no jurisdiction on the appeal against a refusal to discharge a condition to conclude there isn't adequate capacity as the condition requires to be demonstrated, but nevertheless the harm of allowing the discharge hasn't been demonstrated, so I will allow the appeal. The proper course, if the appellant wants to make the argument there is no harm, is to make a Section 73 application. Instead, their approach in the statement of case was to effectively argue it's unnecessary to have a condition controlling capacity off-site, which, as I've said, misses the point because there is one. Nothing in the appellant's submission addressed that capacity question. None of the submission documents you've got listed in the Statement of Common Ground deal with the adequacy of off-site capacity. It is only dealt with in the Southern Water letters. And what has happened is the first Southern Water assertion that there was capacity has been tested by the council through the correspondence you've seen. My submission is properly understood. That doesn't demonstrate adequate capacity, far from it. It demonstrates there is a capacity problem. And so, as we say in paragraph 42 of the statement of case, that is the end of the matter.
Mr. Knowles, come to the appellant. Anything else to add?
You've probably got our points, sir, but again, condition 13 doesn't require scrutiny of off-site impacts. If it is a Barratt condition, you've got my submissions on that point. I don't need to rehearse them again. Southern Water don't allege capacity issues in terms of foul water connection. They say the issue's down to rainwater, and frankly, there's nothing that this development can do to solve that problem, and it will not exacerbate it for the reasons I've described with respect to surface water drainage. Just on the point about habitats, you'll have noted that Natural England's position is that we don't even get into appropriate assessment territory because there is no impact pathway, and that means it fails at the first hurdle, as it were, because there is no likely significant effect. So we don't need to consider the issue any further. That's all. Thank you, sir.
Thank you. Right, in respect of my, in respect of what I listed as the second main issue, I've not got any further questions in relation to that, given what we concluded earlier and the quite thorough discussion we've had in respect of all aspects of drainage. Is there any other planning matters that anybody wishes to raise? Anything from the council first? No. Interested parties? Okay, sir.
Thank you, sir.
Can I take your name, please?
Sorry, Councillor David White, and I represent the Hillingly ward of the District Council. I'm also a District Councillor and Chairman of the Hillingly Parish Council. I chair the Cookmere Flood Forum, and I sit on the Pevensey and Cookmere Water Level Management Board as member of the District Council. My concern, sir, is what I think is fundamental to your inquiry this morning, and that is the capacity and having evidence that the capacity exists to deal with the foul sewage flows. Now, in 2016, when consent was granted for the Rosemead development, there was in fact a very serious consideration of capacity at that stage, and there was a statement of common ground between Bovis, the developer, and the local authorities to the improvements to the system that would be required to accommodate the flows of foul sewage from the 123 house development. And if I can just read from that utilities services assessment prepared by Bovis at the time, which should be on record. I think it's part of the planning application in 2016 for the Rosemead development. That talks about the Copy of Southern Water Level 1 capacity check that there is insufficient capacity to serve the site and off-site reinforcements will be required. The work will comprise the following construction: a Type 2 pumping station upstream from the existing treatment plant, diverting the existing rising main in Horbeach Lane, constructing a 1,028mm new gravity and rising main, plus 11 new manholes, and ultimately connecting into the existing public sewer upstream of the Vines Cross wastewater treatment works. I'm not aware, and I can't see any evidence that that work has actually been completed satisfactorily. And I would like confirmation from Southern Water that that work has actually been done, because if it was identified in 2016 for 123 houses, and we've subsequently received applications for a further 38 on this site and 46 on the Culderbeck site, Culdhaven site, I'm not satisfied that there is in fact sufficient capacity in the system. We have problems in Hellingley, and we called Southern Water to account in relation to a small pumping station there, where we are required to pump out the Southern Water is required to pump out the water on a fairly regular basis. And when asked the question at a public meeting, which was attended by our local MP in Luscani, by Southern Water's representatives, by District Council representatives, when asked the question as to capacity, Southern Water's answer was, well, we tanker it out. So their answer as to whether there's sufficient capacity is, we rely on tankering. We've got 24 months in which to upgrade the system, and if we haven't upgraded, we'll tanker it out. Thank you, sir.
Okay, thank you very much. Anything else to add before
Yeah,
I
just
go to
on
conditions?
level 1 capacity check, they always were performed just as a context. If Chris would come to me and say, back in 2016, can I do development on that site? Yes, the right procedure to begin with to save money is level 1 capacity check, which at the time I believe it cost about £350, let's say. That's the cost of Southern Water level 1 capacity check. In my years of working in those years, there was never one level 1 capacity check which came back saying we have capacity. In fact, we as engineering practice would immediately say to client, jump to level 2 capacity check. That's a detailed design capacity check at which not a desktop study but real hydraulic modeling has been undertaken by Southern Water. And as a perspective, their level 1 was £350. Level 2, I believe it was £2,700. That's, back 2015, 2016, which means it was nearly tenfold of the cost. But level 2, you would always be given appropriate location where capacity is available, what capacity is available immediately. And I don't know the site enough to comment, but I'm guessing from professional experience drawing only on that if they haven't done the upgrade work which was stipulated in level 1, most likely they have done level 2 capacity check at a detailed design stage of further consultation, at which they determined how much space they have. But as I said, the cost of that was tenfold nearly, if you look back on 2015-16.
One administrative point I wanted to pick up with you earlier, which I failed to do, I'm sorry about that. Just with respect to the name of the appellant, I think it was noted somewhere in correspondence that the appeal was made in the name of Mr. Chris Barron, but actually it should be Chailey Holmes, and I understand that that issue had been resolved with the council.
Well, it's certainly been. I'm not sure by the council. It's certainly been resolved internally within the inspectorate. I made some inquiries to make sure that the appeal was valid, basically. So, and I'm pleased to say we're sat here today for a valid reason. So. Right. Okay. If I move on to conditions and obligations. This is likely to be a fairly short section, I think. I was pondering, first of all, which exactly are the documents to be approved under condition 13 were the appeal to be allowed, and is it just a case that the conditions are a fairly simple format, so the decision would effectively say the scheme is hereby allowed subject to compliance with plans, drawings, whatever they may be.
I think they were listed in the statement of common ground, so just trying to do.
That's what I was going to say. There is a list there of I think 10 or 11.
So I think it's
Are you both agreed that
paragraph 3.7
yes,
the statement of common ground? Yeah.
Yeah.
I take it that there's no requirement for a discharge of conditions to have any tail pieces at all, or further impositions as far as the council's concerned. I move on to, I don't think there's no other conditions that I'm aware of at all. In terms of the draft planning obligation, from what I can see, that was in respect of surface water drainage, so it would it now not be within the scope of what's proposed under condition 13, because it's entirely with reference to surface water drainage, which would have been, I'm not sure, would it be imposed upon condition 14? I'm just trying to think practically in terms of necessity, the necessity test for an obligation. Is that obligation necessary to make my decision acceptable? Side of that, I have very few quibbles with the obligation. I've had a detailed read through it, but in light of our initial discussion.
So if it helps, it came about, we'd raised the point, not least in the decision notice, that the agreement with the Water Management Board wasn't there, but again, in our statement of case, that it wasn't there, and the appellants took the opportunity to provide assurances that that issue will be resolved by providing that obligation. I do agree that it isn't necessary if that's the view that you had, but what it does do is provide assurances to all those involved that in terms of surface water and being able to sign off an appropriate scheme, that the appellant is committed to that. Clearly, we've linked it as well to the matter in relation to condition 18, but we discussed that today and all agreed that that's not relevant. And if anything, is more of an enforcement issue were there to be problems in the future with development occupied.
So that is something that the council would pursue under presumably either conditions 14 or 18 potential.
Exactly. So I think it's something that's needed, but it's not needed for the purposes of discharging condition 13.
Yeah.
So it's there for information in the background, as it were.
Yeah. Sorry, I was just going to say, sir, that these matters have all been sort of dealt with together under 13 and 18, and you know what the obligation is there to achieve, and so we certainly have no quibbles with getting it executed in the next week, yeah, and submitting it to the inspectorate. And if you felt like you needed to place weight on it, you then have an executed deed. But we certainly consider that it's necessary in order to secure the payment in any event to the Drainage Board.
Okay, but it would, I wouldn't, now I have to say I'm not quite sure how obligations and discharge of conditions works. It's slightly new territory to me, but if this were a section 73 or section 78 appeal, or sorry, section 73 application or section 78 appeal, I would have to consider it against the Silham framework tests, in which case it seems to me it simply wouldn't meet the necessity test for this discharge of condition. I don't know if it's the same for a discharge of
Well, I think you can only take account of a planning obligation when granting planning permission, which you're not doing when discharging a condition. So I've got no difficulty with it being executed and before you, but I don't think you need or indeed can take it into account as a reason for your decision on the matter before you, which is condition 13.
I mean, obviously, it was put forward to try and overcome the council's objection with regard to the board, and essentially, so we were dealing with a chicken and egg problem, which is that, you know, we want the drainage board's consent, which we had in principle, subject to the payment of the fee, which we were only going to do if we had the relevant condition discharged. So it was to overcome that issue. We'll get the deed executed and submitted to PINS in any event, sir. And if you feel like you don't need to place reliance upon it, then you can say as much in your decision letter.
Okay, what I think I'll do in that case is, given I think I suggested earlier, I might need to adjourn for a few days just to reflect upon the Natural England Section 28 issue. Then, if I feel it's unnecessary for whatever reason, close in writing. So that there doesn't feel to me any harm to say, can you get that obligation? Yeah, submitted within the next week, and I'll give the council a couple of days to respond to it. Although it doesn't, I think we've really discussed it.
There's no difficulty with what it says. I mean, you might conclude that it's an agreed matter between the parties that condition 18 doesn't fall for your decision because it doesn't need to be discharged. As a matter of fact, there is now an executed obligation that deals with some of the matters within the scope of condition 18.
You require a paper copy, sir. We've got copies if you need them. Obviously, it's unexecuted, but in case it makes it easier
no,
to read.
that won't be necessary for just in terms of that, so I had prepared for that. Once I received that obligation, I was fine in terms of section 106.9 A, B, C, and D. It wasn't. The one thing I'd say, it wasn't particularly clear why the amount was required. I appreciate why it was required, but if, for example, we talk about special protection areas, you have a per dwelling contribution, and you understand why that is. It just wasn't quite clear from this what was being purchased in terms of a cubic meter of capacity per site area or something.
There are entire bylaws written which you do. I'm sorry, I completed this application a couple of years ago, but it's based on number of dwellings, total introduction of impermeable areas, and the discharge rate at which you are going. The higher the discharge rate, like you spend less money on site to attenuate, the more money you have to give to Pevensey. So it's almost to discourage people from trying to not go with what you're supposed to be going in case you can do. So the money is always calculated through the simple equation. Number of dwellings, total area which is impermeable being introduced, and the contributing flow on restricted rate.
Sorry, that's everything I had to refer to in terms of planning obligations and conditions. In terms of applications for costs, can I ask first of all, does the appellant intend to submit an application for costs? Right. Okay, thank you. And does the council intend to submit an application for costs?
No.
Okay.
So I have committed it to writing. I'm conscious of the hour, and I'm happy for that to be submitted to you and to my learned friend, so that it doesn't necessarily need to be read out today, if that was helpful to you. But if not, I'm happy to read it as well.
Right. Okay. No, that's useful. I mean, unless the council objects, are you suggesting you perhaps provide me and the council with a copy? The council has, say, 3 days to respond, and you have 3 days to add any final matters in relation to that response. Mr. Knowles. Thank you very much. So, have you? Right. Okay. Yeah. Okay. Thank you. Sorry, I do beg your pardon. I will adjourn in a minute and give the appellant five days, which will probably be from tomorrow morning now when I get the letter sent out to execute the planning obligation, and then that will also give me my thinking time in respect of the SSSI section 28 matter.
Can I just ask in terms of practicality, so whether you're content to receive an electronic version of an obligation, or do you require it be posted?
I did wonder what that button did earlier, and now I've inadvertently pressed it. I'm not quite sure what I've done, but if somebody crashes through the door thinking there's an emergency in a minute. Right. The site visit will be an access required visit. I'm not going to resume the hearing on site, so the purpose of the visit will simply be for me to see the appeal site and surrounds, and not to debate any substantive points. Although the council and the appellant can point out if there's specific features that you referred to in evidence, you can point to those. I don't want to be told of the merits of those features. I think. But yeah, if there's matters you want to point out, who will attend? Actually, first of all, I should ask. It might be determined on whether we can do it this afternoon. Now, I've just had a look. It's about 20. Is it about 20 minutes from here, and it gets dark at about 4:45. Do you think there's sufficient time for me to see all I need to? Okay. Right. Okay. So who will attend for the appellant? Right. Okay. So heating's important. Okay. And from the council
Would be Mr. Batchelor.
Do any interested parties wish to attend that visit? Okay, thank you. In terms of a time, is quarter to 4. That gives us 10 minutes to get out of here and 20 minutes to travel. Is that about reasonable? Do you think? This was coming to my next question as well, because I suppose if I have to park a mile into the village, then potentially it might need a little longer. But no, okay. So this is the recent residential development just to the north of the appeal site. Okay, and I can park in there. Okay, and any health and safety matters or concerns? No animals, holes, or anything like that. Health and safety requirements. Standard diligence for a field. Yeah. Okay. Right, okay, I've spent another couple of minutes talking. If we say 10 to 4, please, at the site. And I will stand away from you until both the council's representative and the appellant's representatives are there. Is there anything else anybody would like to raise before I adjourn? Nothing? No? Okay, thank you. Nothing? Okay, in that case, at 15:18, the hearing is adjourned. Thank you.